So folks, as per usual, we talked about a lot of different things yesterday. And so of course I'm going to ask the question that I always like to ask. Do you understand we're going to get into agency and a lot of the similar concepts more and more, especially tonight and Monday night. And then we're going to move into some other sections, but we will always tie back to some of these agency conversations, as the course continues to go along and we get closer to the end of it. But is there anything at this moment before we pick up and just head into some of the newer concepts that y'all want to talk about, need some clarity on, questions, comments, concerns about anything before we kick it off? While you mull that over, I will let you know, if you didn't see it, I put all of the slides thus far into the GroupMe chat last night. So the introductory day one slides, including the relink discussions, the licensing stuff, moving into the 1 through 5 units, and then of course the slides that we're currently working off of now, all the way through 10 you have access to in GroupMe. I will format the other ones that we will be working in next in the very near future and getting those uploaded into there as well. And of course, I'm going to try to get caught up on all of your videos for YouTube this weekend. So that is the plan. But if nobody's got anything, we'll kick it off. So yesterday we discussed agency in great detail, right? We talked about different relationships. We talked about agency disclosures, the trigger for agency disclosures. And so, folks, what is the trigger for providing the working with real estate agents disclosure in North Carolina under most circumstances? On a side note, before anybody answers that, Eliza, if you send me an email, I will respond back to it and put the links in there. Maybe it's just GroupMe. Just email me and I'll make sure that I add those links. And if it still doesn't work, then we'll change it. But if I attach them to that email, you should be able to open them. Hopefully, I'll get them for you. Good deal. Folks, what's the trigger for having to provide the working with real estate agents disclosure under most circumstances? What do we call it?
First substantial contact.
First substantial contact. Thank you, Kingsley. And what is first substantial contact, folks?
When a customer's motivation for participation in real estate transaction is disclosed.
There you go. When we start getting into some confidential information territory, right? If we start moving the conversation into things that could be used against somebody in a negotiation, then we're having first substantial contact. And that is typically the trigger for giving this working with real estate agents disclosure. Now, let me ask you a question. Is the working with real estate agents disclosure required in all transactions?
No.
Which ones?
Selling transactions.
Sales transactions only. Potential buyers, potential sellers. That's exactly right. Sales transactions only. Both residential and commercial. Now, the other thing that we got into is agency disclosure gets triggered at initial contact. When would you have to explain to somebody that you were already representing a certain person at initial contact?
The second they start telling you something that you could, immediately, right?
Yeah. There's the two different ones, right? There's the working with real estate agents disclosure given at first substantial contact and under most, circumstances. But then there's that time where you would have to disclose your status at initial contact. What was the specific trigger for initial contact?
If you're contacting the other party directly.
You got to be more specific. It can't just be the other party.
The other party in the sales transaction.
Nope. It is a very specific side.
Must also disclose their status as buyer agent as soon as initial contact is made with seller or seller's agent.
There you go. If you are already representing a buyer and you pick up the phone or you reach out to a seller or a seller's agent, you have to disclose your agency status as a buyer's agent at initial contact. There is no waiting for them to say something that triggers it. If you are already representing a buyer and you're contacting a seller or a seller's agent, folks, you know as a buyer's agent you have this conflict of interest. And because of that thing called seller subagency, you have to tell them the second you start talking to them so they know, are we on the same team or are we not on the same team? Does that ring a bell?
Yes.
And I promise you, North Carolina, it's very testable. Folks, let me show you something just to kind of go along with this little recap. Last night, we had some discussions on the License Law and Commission Rule Book. Let me find it here. And so I'm going to show you if I can, well, I'm going to show you the rule because I promise you all the different pieces of this rule are extremely, extremely testable in North Carolina. Now, some of the stuff does overlap, but if you go to the commission rules, which is on page 50, you've got a big list of different rules, and we're going to talk about a lot of them throughout, especially when we get into the Section A, or the, I'm sorry, not Section A, but the more deeper rooted license law and commission rule book discussion. But I want you to notice this particular rule right here. A lot of what we're talking about stems from this one right there. Agency, agreements, and disclosure rule, 58A.0104. Promise you never need to know these numbers. I just relay them as that because that's what I know them as. But if you go to 58A.0104, right here, this is where it outlines certain things. I want to show you that specific piece. There you go. Let me zoom in a little bit right here. In every real estate sales transaction, a broker representing a buyer shall, at the initial contact with the seller or seller's agent, disclose to the seller or seller's agent that the broker represents the buyer's interest. In addition, in every real estate sales transaction, other than auctions, the broker shall, no later than the time of delivery of an offer to the seller or seller's agent, provide the seller or the seller's agent with a written confirmation disclosing that he or she represents the interests of the buyer. The written information may be made in the buyer's offer to purchase and shall include the broker's license number. Now, this is where I kept kind of misspeaking a couple times yesterday, because understand that this disclosure starts out verbally, but will ultimately be made in writing. Oddly enough, it is not typically made on the working with real estate agents disclosure for this buyer's agent giving the initial contact to the seller or seller's agent. The way that it's ultimately made in writing is on the offer to purchasing contract, which we'll get into later, probably not this evening, but later. And that is where, you know, it will outline who is the buyer's agent, who is the seller's agent. And so that just confirms and reiterates your relationship. So that's that special category. And folks, it is a licensed law in North Carolina, which means it is very testable on the North Carolina portion of the state licensing exam. Now, if I backtrack a little bit, when it's talking about the overall rule and the disclosures, in every real estate sales transaction, a broker shall, there's that word, sales transaction, a broker shall, at first substantial contact with a prospective buyer or seller, provide the prospective buyer or seller with a copy of the publication working with real estate agents setting forth the broker's name and license number thereon, review the publication. And so understand that when I'm talking about this agency disclosure, sales transactions, both residential and commercial, triggered by first substantial contact with both potential buyers and sellers. The only time it's special is if you're already representing a buyer, and that's the one we just talked about. And then you also have to review it with them, and it is always going to be tested as a written disclosure because it is an actual form that we have to provide to them. Okay, so we talked about this working with real estate agents disclosure yesterday, and you make sure that you're very comfortable with it. Remind me, folks, what is the one thing that a working with real estate agents disclosure will never do?
be an agreement.
It will never create an agency relationship. It is not a contract. It is not an agreement. It is a disclosure only. Here's how it works. Okay, well, let me ask you another couple review questions before we move on into bigger and better things. Folks, what is the definition of dual agency?
Two sub-agents working for the same agency representing two parties that are against each other in a transaction.
That's correct, but there's an even simpler answer than that.
Worthless.
Well, worthless, but there's a more detailed answer than that. Yeah, we're on the two ends of the spectrum, right? You gave me too much detail, you gave me too little detail. How do we define dual agency?
When the broker represents both the buyer and the seller with equal loyalty, so it's fair.
Yeah, I just add in like one more tiny piece. Represents the buyer and the seller in what? In the same transaction. There you go. So let's just piece that all together. When the firm represents the buyer and the seller in the same transaction. Now, Adriana's use of the term broker was okay as well, because you would see that on the national side. And it could be a sole proprietorship. It could be a brokerage. It could be a broker. It could be a firm. But at the end of the day, think firm, because that's how you're most likely going to be tested on the North Carolina side of things. So it's when a firm represents a buyer and the seller in the same transaction. Don't get caught up on firms that work with buyers and sellers. That's not dual agency. It's not dual agency. Now, folks, I'm going to go ahead and introduce, well, I'm going to tell you something, and I'm going to reiterate something you already learned last night, which will give us a segue for what you're going to see later today. We were talking about exclusive representation last night, okay? When I said buyer agency, that means we exclusively care about who?
The buyer.
The buyer. When I say seller agency, that means we exclusively care about who?
Seller.
Seller. Okay? So the thing is, every single relationship, agency relationship, starts out as exclusive. But it doesn't necessarily stay that way. Because if we sign a buyer agency agreement, but then they authorize us to act as a dual agent, it started off as exclusive, but now it's not if we go into dual agency. Does that make sense for everybody? Remember when I picked on Jacob and I said, Jacob, if you don't know what exclusive means, try bringing home another girl and see what happens to you. He said he'd be dead. So in exclusive, right, it's just the two of us. But when dual agency comes in, it's no longer exclusive anymore. Well, folks, let me see how much you're tracking with me here. I want you to think about this. Do you think there are times that buyers and sellers would state, no, I don't want dual agency, I want exclusive representation only? You think they might say that sometimes?
Yes.
Sure.
Yeah.
And so I want you to think about this, based on what I've told you, based on everything that you've kind of surmised so far. If a seller was to tell their agent, we want exclusive representation only, what does that mean for that seller?
And it means that you are the only person that can work with them.
It means we're the only people that can work with them. What else does it mean?
Does it mean that they need to both represent the buyer and the seller?
No.
Can you please just ask that again?
Absolutely. If who just asked me to repeat that? Monica. Monica, you are my seller, okay? And Monica, you and I have a listing agreement together, which means I am your agent. And when I ask you if dual agency is okay, you say, no, I want exclusive representation only, Seth. I want you to look after my best interest and my best interest only. No dual agency. What does that mean for you, Monica?
Means that I'm not going to be entering into anything but a designated dual agency situation.
You're not even going to be entering into that, because if you say no dual, that means no designated either.
Really, even if they understand I'm lowering my fiduciary duty on both sides.
Yeah, so when you say you want exclusive representation, that means dual is off the table. No dual, no designated dual. So tell me what else that translates to. Folks, think about it.
You have to procure the buyer yourself. I mean, an outside buyer or agent would have to come into the picture. If you can't do dual, then an outside agent or an agent that is not yourself.
Thank you. That's exactly what it means, folks. Understand that. What if I work for XYZ Realty and we have 10,000 buyers that we have agency agreements with right now? Not a single one of our buyer clients that we're representing can see Monica's house. Because if we take them to see Monica's house, what would that be?
Dual agency.
Dual agency. And what did Monica say that she was not going to do?
Dual agency.
Dual agency. Do you see how that works?
So no sub-agents, is that right?
Well, no, we could have sub-agents as,
They have to be outside.
well, we could have seller sub-agents internally, right? Remember, we could have other people in our firm who are also representing you working with buyer customers. So we could assist buyer customers, but that means we are giving you exclusive representation, right? There's that word. We are only looking at, as a firm, we are only looking after Monica. So if we are working with any buyers dealing with Monica's house, they are a what? Repeat it for me. Customer.
Or customer.
There you go, a customer. Because we can't represent them. Monica said she wanted exclusivity. Now, let's take this same thought process, folks. Let's flip the coin. What if Jacob was a buyer I was representing with XYZ Realty? And Jacob said the same thing. Jacob says, I don't want dual agency, Seth. I want exclusive representation only. What does that mean for Jacob?
I know syndicated buyer agency will be clear with them. Because you switch it. This is my question to you tonight, is when you switch it for buyer agency, the property buyer becomes a client, the property owner is the customer. Is that not the scenario you're explaining?
Well, so I replaced you, right? We got through your scenario. So now I'm not even talking about a house in general. I'm just saying Jacob calls me up. He hires me to be his buyer's agent. I'm giving Jacob exclusive representation because he doesn't want dual agency. So what does that mean for Jacob as we look for houses?
Jacob cannot see any of the houses that the firm has listed.
There you go. It's the same, right? If the buyer wants exclusive representation, that means they cannot see a listing that is held by our firm. Because if they were to see it, that would be dual agency. That word exclusive is very powerful, isn't it? Now, the thing I'm setting up for that we'll segue into in a moment, there are actually two different contexts of the word exclusive. Same meaning, but a different context. And you're going to find that out in a moment when we get into a later topic. But does this make sense for everybody? If your client says no dual agency, that means they can't have dual, they can't have designated dual. All they can have is exclusive representation. And that means that has limited their pool of either buyers as a seller, or that's limited their pool of homes as a buyer. Because they can't see our firms. Does that make sense?
Do you explain that to them before, like, the contract and everything is set, or no?
Yeah, you explain it whenever we're asking how our relationship's going to go, right? We're basically going to say, well, can I be your buyer's agent? Okay, great. So yes on buyer agency. Can I be a dual agent? And they're going to say yes or no. And then you're going to say, great. Of dual agency, can we do designated? And they're going to say yes or no. And then we say, okay, great. We're going to have a conversation with them about these things. But understand the way it works in the real world and the way it works on the test is different. All the questions that you're going to be asked are exactly what I'm telling you right now. It's going to say something like Dora is being represented by Josh of ABC Realty, and Dora wants exclusive representation only. How is that going to restrict Dora's home buying experience? Dora will not be able to see a single home listed by Joshua's firm, ABC Realty, or whatever I just said, because that would constitute dual agency. And if we were to do that, it would be illegal dual agency, because you did not give us consent, and you cannot do dual agency without informed and written consent.
Seth, just to make sure, I'm pretty sure I know the answer, but I just want to make sure. So yesterday when you showed, I think it was 15 HPWs, but it's all one firm, but they're in different locations. So you can't see any house that's listed by any of those.
No.
Correct, because it's one.
Correct. It's all one brokerage firm.
Okay.
Yep, you nailed it. You nailed it.
I got it. Okay.
Why would someone want to do this?
Well, it sounds good, doesn't it? Exclusive. Listen, here's the ironic thing, Kirsten. You asked me why someone would want to do dual yesterday. Now you're asking me why somebody would want exclusive. You see how you're...
Always want to know why.
No, I agree with you, but it's all in how you spin it. And it's all in how you look at where it is an advantage to you and a disadvantage. The advantage to you is never, ever, ever having to worry about a conflict of interest. Your person is your person, and they are going to look after you from the word go. The downside, of course, is missing out on potential buyers as a seller or missing out on potential listings as a buyer. But if you could live with that, then asking for exclusive is fine. But the reason why I agree with you that we should all be confused as to why they'd want to do that, well, it's because maybe they don't understand just how amazing designated dual agency is. Because in designated, we can open that pool up and still basically act like exclusive. Don't ever call it exclusive because it's still a type of dual, but it acts the same. We can actually look after your best interest. We can try to get you the best outcome. We can go for blood. But, you know, in the real world, very seldom do people have a problem with dual agency, especially with firms that practice designated. It just doesn't make a whole lot of sense. But as I said before, you're going to be tested on this on a very, black and white level. If this, then that. If this, then that. If this, then that, right? They said they want exclusive representation only. What does that mean for them test-wise? You got to know it. They said they're okay with dual. What does that mean for them test-wise? You're worthless. They said they're okay with dual, but if dual they want designated, what does that mean? Well, it's not exclusive, but it acts like exclusive. It will all be bracketed, and you have to follow the rabbit, as they say, because it will not be straightforward. They will not spell it out like I do. It will just say such and such with ABC Realty wants to see a home by ABC Realty. But this person is authorized exclusive only. Which of the following would be a true statement? This person can't see it because that would be dual agency and they want exclusive representation only. This person can see it as long as they get a high five before they go in. This person can see it, but they can't put an offer unless they change their mind. It's going to give you a lot of different things, right? And you've got to be able to kind of follow it and work through it and kind of decide what the best answer is depending on the scenarios given. Now, before we even get into the agency agreements, which is fast approaching, that's the next thing after we get through the doctrine of caveat emptor. Let me go ahead and make a statement. You can change your mind, okay? Rest assured. So let's say that you want exclusive representation only. There might be a time that you're like, but I really like that house y'all have listed. And we can go to you and say, do you want to change your mind? And I promise that's going to be testable as well, right? And I'm going to explain that when we get there. Everybody okay with some of this recap from yesterday before we get into the next thing?
Do they have to fill out a new
Agency agreement?
yeah.
They just have to acknowledge the change. Sometimes you can just make the adjustment to it. It's called an amendment. We're going to talk about this. So you can keep the same one, but you would go in and make a change to it and have all parties initial it. Or we have a document that we can use called an amendment, which would, allow us to make a change to that document. Yeah. Manoj, were you about to say something?
No, I was going to ask, you were showing some disclosure form yesterday, the buyer agreement, the buyer disclosure form at the very beginning.
Mm-hmm.
So we have to check all 3 boxes on that form. I think as far as I remember, there was a dual something in there.
Yeah, you would check remember, that will always come before the agency agreement. So what we're talking about right now is agency relationships. You would have already had that conversation with them. And all that was saying what your firm possibly offers. Does my firm offer buyer agency? Let's check the box. Does my firm offer dual agency? Let's check the box. Does my firm offer designated dual agency? Let's check the box. That's not saying what they are or are not getting. It's just saying this could arise if you end up working with me. But you don't actually get the consent on what you're doing until the agency agreement. There you go.
Okay.
For Caveat Emptor,
Sorry, go ahead.
I understand that the seller does not have to disclose any.
Hang tight on that because I haven't gotten back into this yet. This is where we're going to start today. Right now, I'm just reviewing stuff from yesterday.
Oh, okay.
Yeah. What were you saying, Monica?
Just the acronym old cars, that represents the entirety of the fiduciary duty. Okay, and then that obviously gets lowered when we enter into dual, or I'm sorry, designated.
So it doesn't necessarily get lowered. They just kind of counteract each other, right? It's basically like you drink a poison, then you drink an antidote. Like you there's something that's supposed to happen, but it can't happen because of this. So when you owe disclosure to this person and confidentiality to this person, you disclosure to this person, confidentiality to this person, they basically negate themselves, making them worthless. For all intents and purposes, you do owe old car to both, but you're not legally allowed to do that because that would mean that you are not doing dual agency correctly. It doesn't get lowered. You just can't do anything anymore. It's because you owe it to both.
There's like three things of the old STAR acronym that we no longer have to fulfill. What is it? That's just the part where I got my thinking, I guess, a little.
Well, and so I mean you're right, but don't think of it as like specific ones disappear. It's just that you really can't do any of them because you owe them to both, right? Because you owe confidentiality to both. Well, you owe disclosure to both, but you can't disclose anything, so disclosure goes away. Confidentiality stays. Reasonable skill and care, you have it, but it's worthless because you can't give any advice. So they all are basically just become a moot point. And so you're not going to be tested on like which three disappear, which three stay. That's not going to be a test.
Except loyalty, exclusive, or principal.
Yeah, and so the test questions are never going to come down to that. It's basically just you can't do any of them anymore.
Okay.
Yeah,
Thank you.
absolutely. Corey, you're hidden over there. Corey, what do you got in front of your camera, Corey? What is that? Looks like you're trying to be Batman.
I have nothing hidden from my camera right now. I don't know what is going on.
Do you have a shutter on your laptop that's partially closed? There's just like something. There we go. That's it. There you go. I was like, you look like Two-Face for a second, Corey. It was just like one side of your face was all I could see. I'm like, where's Corey? What's going on? There you go.
Yeah, you was right. So the shutter was been on though.
Yep. No worries. No worries.
Oh, wait a second.
Oh, there. You close it. Now it's open. There you go.
All right.
No, there you go. So, folks, let's pick up where we left off yesterday, if everybody's feeling okay. And we're going to talk more about agency. Don't think it's dead. I just need the agency concept has to be more than agency, right? We have more things to talk about, like the caveat emptor and a couple other disclosures, and we'll get into some other things like measuring houses and CMA. So it's a very broad category. It's not just, agency relationships. So the doctrine of caveat emptor in North Carolina, okay, very, very important doctrine. And I told you yesterday, it loosely translates to let the buyer beware. And the way I articulated it was the seller has zero, mostly, disclosure obligation to the buyer in regard to their property. If the seller knows that they have an issue, they do not have to disclose it in any way, shape, and form. Now, I keep saying mostly because if you recall when we started talking about environmental, that lead-based paint disclosure didn't give them the option to withhold information. Because that is a piece of national legislation, it supersedes the doctrine of caveat emptor that we hold true in North Carolina. So they are required to answer the lead-based paint disclosure questions, and we also state that they are required to answer what we call the mineral, oil, and gas rights disclosure questions, which we'll get to. But everything else is whatever they want to say. If they don't want to say, they don't have to. If they want to say, they can. The only rule is they cannot try to commit fraud, or misrepresentation, or to cover things up. So this does not ever apply to a real estate broker. This is where some students make mistakes. They're like, oh, well, an agent doesn't. No, this is only between a seller and buyer. Only between a seller and a buyer. And so the seller is not going to be held accountable if they don't disclose something, as long as they didn't commit fraud or misrepresentation. Now, if they committed fraud, a misrepresentation, anything like that, you could potentially take them to court. They could be subject to disciplinary action. And so I'm going to introduce a concept in North Carolina called the Residential Property Disclosure Act. Okay, the Residential Property Disclosure Act. So before I go any further into the Residential Property Disclosure Act, I'm going to reiterate, the seller does not have to disclose the problems with their property in North Carolina. However, in order to mitigate this concept of the doctrine of caveat emptor and make it suck less, we have a disclosure that is required for the sellers to provide. And we also have material fact disclosure laws that is required for the agents to disclose. This is the way we kind of combat this and make it a little less terrible. So the disclosure form is required, but the disclosures on the form are not. Give me a second. I'm going to pull this form up and I'm going to show it to you. And it's probably just easiest to pull it up here again. So let me slide this over. Back on the Real Estate Commission's website, just because it's a really easy place for me to kind of hunt these things down. There's that working with the real estate agent's disclosure. Here's the property disclosure, and here's the mineral oil and gas rights disclosure. We're going to start with the property disclosure, okay? Now, I think I've said this before, but let me say it again. In the real estate world, we love our acronyms. We really, really do. And so the working with real estate agents disclosure is typically abbreviated to WWREA. This one is called the Residential Property and Owners Association Disclosure Statement. We call it the RPOADS for short. RPOADS. RPOADS. What a beautiful name. So this is required in most transactions, most residential transactions, but there are some exemptions to when it's not required. Let me name off some of the times that this is not required for a seller to provide a buyer. New construction is exempt from providing this form. Foreclosures, transfers between co-owners, lease with option to purchase where the lessee already occupies the property, any commercial deals. If the parties agree that this isn't required, there's a lot of times that this could technically not be required, but for most residential resale transactions, it's required. Now, as I said before, the form is required, the disclosure is not. Let me show you what I mean. If you look at this form, it is 4 pages, and really starting on page 2, there's questions. Questions we ask the seller to answer. And so let's just take number 2. So you can see kind of what the feel of these questions. Is there any problem, malfunction, or defect with the dwelling's foundation, slab, fireplaces, chimneys, floors, windows, including storm windows and screens, doors, ceilings, interior, exterior walls, attached garage, patio, deck, or other structural components, including any modification to them? That's a pretty loaded question. But the idea here is there are questions that we ask the seller to voluntarily answer. But look at their answer choices. Yes, no, I plead the fifth. 1, 2, 3, 4, 5. Yes, no, or no representation. Okay, no representation is I plead the fifth. I'm not telling you nothing. And so I want you to understand something. When you say yes, you are saying yes, there is an issue, and we ask you to explain it. When you say no, you are not guaranteeing that there's not an issue, but you're saying no, I have no actual knowledge of an issue. You would not be held liable if there was one and you weren't aware of it. Somebody would have the burden of proof of proving that you lied or committed fraud. And then no representation is there may be a problem, there may not be. I'm not saying nothing. And it even says that on this form, right? If you come up here and it says, if you check yes for any question, you must explain your answer and either describe the problem, attach a report, or otherwise. If you check no, you are stating that you have no actual knowledge of any problem. If you check no and you KNOW, no, there is a problem. You may be liable for making an intentional misstatement. And then no representation, you are choosing not to disclose the condition or characteristic of the property, even if you have actual knowledge of them or should have known. So let me give you a couple examples of this. If you look at this one, is there any leakage or other problem with the dwelling's roof? If the seller knows, KNOWS, knows that their roof leaks, they have one of two options when answering this form. They would either have to say yes and then tell you their roof leaks, or they could say no representation, which means you figure it out. Either way, they are completely legally okay in North Carolina. But if they know that it leaks and they come in here and say no, and you can prove that they knew, they can be held liable for fraud. Everybody understand this? This form is mandatory. The disclosure is optional. Because in theory, folks, what's stopping a seller from going the whole way down and saying, not telling you nothing, mind your business, stick it where the sun don't shine, whatever, yada, 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 right? Nothing's stopping them. What you got, Adriana?
So this no representation option, it's valid in all states or just North Carolina?
This is the North Carolina disclosure. And the reason why this is a North Carolina disclosure, Adriana, is because not every state practices the doctrine of caveat emptor. In fact, we're the minority. Some states have disclosure laws the seller has to abide by. Some states require the seller to say everything that's wrong with your property. North Carolina's not one of them because of this old school doctrine. And so the way that we combat this is by making this form mandatory, so that in hopes that you would disclose things. And then, of course, putting material facts disclosure laws a lot more strict and imparting them on the real estate licensees.
So then it's up to the buyer's agent to request or suggest the inspection.
Yes, it is always advice that we should give to get a home inspection. If you ever buy a house in North Carolina without an inspection, it's the stupidest thing you'd ever do. No offense if any of you have done that in the past. Not trying to add insult to injury, but it's a very dumb thing to do to buy a house in North Carolina without an inspection. Yeah. What you got, Kirsten?
So if you're going to get to this, tell me. If you want me to put it in the parking lot, tell me. But if I'm representing a seller, am I going to coach them on completing this form, or do I just say, here's a form, please read it and fill it out to the best?
Good question. So here's the deal, folks. Understand there's a couple very testable pieces of this form, all right? I've started scratching the surface on it, but here's the other ones. This form is required even when a real estate broker is not being utilized. So a for sale by owner is also bound by the Residential Property Disclosure Act, which requires this form and one other. And so when there's no broker, they're responsible for finding it themselves, filling it out themselves. When there is a broker, they hire us to assist them in selling. We are expected to provide these forms to them, and we can give advice on, things that they may not understand. But it is very important to understand on the test, and they will ask you questions about this. Who fills this out? The seller. The pen is in their hand. We can never fill it out for them to make their lives easier. We can never tell them what to answer. But can we help them understand some of the questions on there if they're confusing or ambiguous to them? Yes. But it is their disclosure to fill out. But we provide them the disclosure and tell them they have to fill it out. Well, folks, I keep saying you have to fill it out. So if they have to do it, you might imagine there's some penalty if they don't. There is. I'm going to explain the penalty briefly, but it'll make more sense when we get to the sales contract section. When you get under contract on a home in North Carolina, it is typically accompanied with a due diligence period. Now, folks, due diligence money is given in order to buy a period of time to investigate a property to decide if you want to move forward with the transaction or terminate. And if you terminate during your due diligence period, you lose your money. Well, here's the thing that this form does, because I told you it's required to give you this form, even if it's no representation the whole way down. As long as it's not an exempt transaction, this form is required. Watch what this says. If the owner does not give you, this is the note to the buyer, because they have to get this before they make an offer. Let me make that statement. This has to be provided to the buyer before they make an offer to purchase on a property. So it says, if the owner does not give you a residential property and owners association disclosure statement by the time you make your offer to purchase the property, you may, under certain conditions, cancel any resulting contract without penalty to you as a buyer. To cancel the contract, you must personally deliver or mail written notice of your decision to cancel to the owner or the owner's agent within 3 calendar days following your receipt of this disclosure statement, or 3 calendar days following the date of the contract, whichever occurs first. Goes on to say, however, in no event does the Disclosure Act permit you to cancel a contract after settlement of the transaction, or in the case of a sale or exchange, after you have occupied the property, whichever occurs first. So let me explain this. If you were to get under contract on a house as a buyer and you were never provided this form, normally the only way you'd be legally allowed to terminate without being in breach of contract was during your due diligence period, but you would still forfeit your due diligence money. But what this states is you have 3 days if you get under contract without this being provided to you to terminate, and you get your due diligence money back when you normally wouldn't. So that's kind of an important thing. It's not a long period of time. That's kind of an important thing. I mean, that could be the make or break between large sums of money, depending on what you negotiate. So there are a lot of different questions on here. These questions individually, not testable. You just have to understand the concepts. There's just so many questions that the specifics are not going to be testable in any way, shape, and form. But this form has to be provided to a seller or to a buyer, filled out by a seller prior to that buyer making an offer to purchase. And this rescission period will make more sense when we get into the sales contract. Now, let me show you the other side of this, folks. Once upon a time, this was the only thing within the Residential Property Disclosure Act. But then they amended it. An amendment is a change to a legal thing. That's all the word amend means. And we're going to talk about amendments in the contract section more. They amended the Residential Property Disclosure Act and they added in a second disclosure. This is called the Mineral, Oil, and Gas Rights Disclosure. Once again, we love our acronyms. We call it the MOG, the MOG for short. Now, there's a couple important things about the MOG. This came into play because there were new construction builders out in Texas severing off the mineral, oil, and gas rights prior to closing. Remember when we talked about the estates and ownerships and the property section, and we said subsurface rights, while they are typically in appurtenance, they can be severed off and sold off. So there was a builder that got in trouble for being sneaky and retaining these subsurface rights. And so North Carolina said, no. We're going to create a disclosure where people have to disclose if that's their intention. So notice the difference on this one. There is no representation in 2 spots only, but that is only in reference to the previous owner. So the mineral rights were severed from the property by a previous owner. The current owner can say yes, no, or I'm not saying nothing. But when we get into the actual seller who's actively selling, seller has severed the mineral rights on the property, you only have the options of yes or no. So this is one of those times where no representation is not an option. Seller intends to sever the mineral rights from the property prior to the transfer of the title. Yes or no. And then oil and gas rights, we kind of keep them separate. Mineral versus oil and gas. Previous owner, yes, no, no representation. Current seller has, yes or no. Intends to, yes or no. They do not have the option of no representation in regard to themselves on the MOG. But they do in regard to the previous property owner. The same protections exist for this one. If they're not given this in a transaction where this is required prior to a buyer making an offer, the buyer would still have that 3-day period to cancel after a resulting contract for failure to receive these disclosures prior to getting under contract. Under the Residential Property Disclosure Act, the RPODs and the MOG. How are we feeling?
Pretty good.
Huh? Nothing too crazy. Justin, I know it's a lot of information, right? We just keep throwing one thing after another, after another. Justin's like, just beat a man while he's down, okay? Listen, we haven't even gotten into the financing stuff yet. I'm sorry. Ugh. I know. Remember on day one when I said this is probably going to be the hardest thing you'll ever do in your life? I wasn't kidding. It's a lot. So we will talk more about these as time goes on, but I've got some things in the slides that kind of go hand in hand with this. Told you Residential Property Disclosure Act requires the RPODs on most resale residential properties. Okay, I told you new construction is exempt. Also understand that residential mostly defined as 1 to 4 units. Anything up to a quadruplex is still considered residential. Anything with 5 units or more is considered commercial. Of course, office space is commercial. So it would have to be something 4 units or less to require this, and it would have to be resale because new construction is exempt from the RPODs. I told you the other exemptions: new construction, lease with option to purchase with a lessee already occupies the property, foreclosures, transfers between co-owners, and divorce. Those are really the only ones you'll ever see on the test. They're not going to throw any more at you. So, as I mentioned just a few moments ago, the seller has to fill this out. We can answer any ambiguities, help them understand it, but they have to be the ones that fill it out. We cannot do it for them. Remember I told you this would be required even in a for sale by owner. They would just be responsible for finding it themselves and figuring it out themselves. But when a broker is utilized, we provide these forms to them and make sure that they understand their obligations here within. So the other piece that I've told you is, please don't ever confuse this with our obligations as real estate professionals. We have an affirmative duty to discover and disclose what we call all reasonably ascertainable material facts, things that you can figure out. And so I gave you the example before we ended the night last night. If the seller knows their roof leaks and tells you it leaks, and then the seller turns around and fills out this property disclosure and they say no representation in regard to the roof leak, and then you as the agent never disclose, only you're in trouble. Because you have an obligation to disclose regardless of how they answer any questions on this. And it even says that. Let me pull this back up just so you're not confused about this. You look right here. If you are assisted in the sale of your property by a licensed real estate broker, you are still responsible for completing and delivering the disclosure statements to the buyers, and the broker must disclose any material facts about your property which he or she knows or reasonably should know, regardless of your responses on the disclosure statement. So we've got to sing like a bird regardless of how they answer. And this goes back to, remember, this law superseding old car. Sure, we owe them confidentiality and we owe them obedience. But if they told us to keep this a secret, that would constitute an unlawful instruction. And I told you under that obedience, we only follow lawful willful instructions.
So is it never required that the agent that's representing the buyer needs to provide or try to find the issues that are pertinent to the property?
Oh, no, of course we are. Every broker has an obligation to help discover and disclose all things. If I'm the listing agent, I need to figure out things about my seller's house and try to disclose them to the public. If I'm the buyer's agent, I need to help my buyer try to figure things out before we make an offer. So like as I'm walking around the listing, Josh, I'm looking for, water damage and things in the crawl space and all kinds of stuff. And I'm going to look at my buyer. I'm going to say, hey, there's some issues here. We might want to do some inquiries. We might want to ask some questions. So there is an obligation to discover and disclose material facts on both parties, listing agents, buyer agents alike.
Is there a recommended way for someone to do that? Like just to, I guess, minimize the responsibility? Like if I'm not sure of how to pinpoint a crack in the foundation, if you will, like how would I eliminate me being responsible from that, especially if the seller isn't going to disclose it?
You can't.
Okay.
I remember that reasonable skill and care. This is part of our jobs, right? Like we have to kind of get a little well versed with. Here's the thing, Josh. We do stay in our lane. Say what? Oh, you muted back. You're muted. You're muted, Josh. You're muted. There you go.
I was saying, I think Misty put home inspection, and I was saying, I was thinking like besides the offering the home inspection.
Well, and so the home inspection, we don't do that until we're already under contract. And sometimes these are what we call red flags, folks. These are things that we need to notice before we go under contract. And so if I'm working with a buyer client and I see some water stains and I see some standing water in the crawl space and I see some stuff like that, I'm going to look at them and I'm going to say, listen, we need to ask some questions from the seller, try to get some answers before we put in an offer. Or we need to go with an offer that has low or no due diligence so we can walk away without penalty if there's anything that's really questionable. So we do get a feel for, what is something that's not a good thing and have conversations with them in order to help protect them. Understand though, we're not structural engineers, so I'm not going to say something like, don't buy this house because it's got structural issues. I can't say that, but I can see a crack. So my obligation would be, hey, Mr. and Mrs. Buyer, there's a crack in the foundation, maybe superficial, may not be. I don't know. Keep that in mind when we start looking at this property a little more in depth. So it's not a perfect science, but we do have to try to find these red flags and give as much information as we can on them to help them understand what they're getting themselves into.
Years ago, Seth, I did have buyers that would pay out of pocket for the home inspection prior to contract because they really loved the house and wanted to be sure. So, I say the safest is a home inspection always. If you really love it, it's worth the money.
Here's the devil's advocate piece.
Due diligence period too, right?
The home inspection is part of the due diligence period. What Misty said, hold on.
That didn't exist back in my day.
Yeah, right. Due diligence periods weren't a thing back in the day. And so understand something. So Misty was talking about getting a home inspection before you went under contract, but that was before due diligence. And so in theory, could you negotiate with a seller to let you have a home inspection before you get under contract? Sure. But then you turn around and you pay a $600 home inspection and then an offer comes in while you're waiting on the results and they accept that one, you just wasted $600. So if you don't have any skin in the game, the seller will take an offer. So there's a big risk to doing that, but it is something that you could do. But yeah, the due diligence period is a very important thing that's in play in North Carolina nowadays. So, but we're going to talk more about red flags. It is part of our job to kind of point things out.
Back then, you could put in an offer contingent on the home inspection. So
yeah,
it's just different. We didn't have a due diligence period.
It's changed a lot. That's right.
Yeah.
A lot of people were getting under contract.
Right?
Say what?
You can still put in offers contingent with contingencies. Right?
Sure you can. We're going to talk about contingencies, but yeah, sure you can. They're just not very commonly accepted because you'll find that contracts have to have mutual agreement. Well, why would a seller agree to that when there's some other fool who's willing to put a contract without any kind of contingency? So we'll get into all that contract stuff in the near future. Y'all hang tight on that.
And I guess last question, the due diligence period will only go into effect once that document is signed by the seller and filled out. Signed by the seller.
Yeah, the due diligence period is part of the contract. And so we're going to table that because we'll get into that in the contract section. Because there's ways that, like, it can end, but it is a part of the contract, the standard one that we use more often than not in North Carolina. And so we'll talk about the triggers for that when we get to that point.
Okay.
Yeah. So the other part that I told you about, they amended the Residential Property Disclosure Act and added this MOG, the Mineral Oil and Gas Rights Disclosure. I told you, big difference here. New construction is not exempt from this, whereas the RPOD's new construction is exempt from. The reason this was created was actually new construction, because it was a builder that was getting in trouble for severing off the mineral oil and gas rights. So North Carolina specifically stated that new construction is not exempt from this. And remember, I told you, the seller cannot say no representation. They can only say no rep in regard to the previous owner. Previous owner.
Foreclosure?
So technically it's not required on a foreclosure either. And then it's also obviously not required on commercial. And so understand that land by itself is commercial. And so technically if you're just buying raw land, they're not required to give you this. But new construction, meaning they're selling you a lot that they're going to build on for you, they would be required to provide this still. And you can always ask for it. But yeah, technically foreclosures, vacant land, which because it's commercial, are exempt from this. But new construction is not. This is very much required in new construction. That's the most important thing to know. It's required in most residential transactions, including new construction. But the same protections exist. Whether you receive the RPODs or you didn't receive the RPODs or the MOG, only missing one is powerful enough to give you that 3-day rescission period we were talking about. So let me circle back around to a question dealing with agency topics, and I want you to tell me what you think. And I will give you the ability to pick as many answers as you think apply with this question I'm about to give you, okay? So I want you to take a minute. Don't rush into it. So here's the question. An agent must have a buyer agency agreement signed when?
Whenever they're going to make an offer. Or
What did you say, Kingsley?
2 and 3.
2 and 3.
I would say number 1.
two.
So this,
I would say 2.
here's the thing. This is exactly why you have to be so careful on the test, okay? Hold on. You've got to read into every possible scenario. Folks, remember, what is 2 plus 2?
4.
4. But don't look for 4 on this test when I ask you a question you think you know the answer to. You analyze every single answer and pick the best answer. I told you you could pick multiple ones. Kingsley got it. Folks, it is 2 and 3. 1 is dealing with first substantial contact. Well, folks, first substantial contact is the trigger for what?
Working with real estate.
The agency disclosure. And we're talking about what?
Agreement.
An agreement. I told you, don't you ever confuse the disclosure with the agreement. It will eat you alive on the test. Those are two vastly different things. So we're saying, when do you have to have a buyer agency agreement signed, not a disclosure? And so you can operate with an oral buyer agency agreement up until the time that they want to put in an offer. So that would require number 2 to be true. Because if you want to put in an offer, you need a written buyer agency agreement. But remember, what 2 things are an oral buyer agency agreement? Come on, folks. We use the dating analogy. What two things are an open buyer agency agreement always, an oral buyer agency agreement always in North Carolina?
Exclusive.
No. Non-exclusive.
Non-exclusive and
Open-ended.
open-ended. Folks, oral buyer agency agreements are dating. You cannot bind them to you. Remember the let's get married comparison I gave you yesterday? When you enter into an oral buyer agency agreement, they are not exclusive. You cannot stop them from working with other agents, and you cannot put a period of time on it. And so number 3 says, well, at the time you want to limit them to working only with you, the only way you can have an exclusive agreement is in writing. So 3 is also a true statement. So it is in fact 2 and 3, not 1. Everybody see how you got to flow through your brain on this to kind of make sure you're hitting it from all the angles? Now, the good news is there's not multiple right answers on your test, but there is multiple answers that at quick glance will look right, but you've got to read into them. Don't look for 4. Read them all, reread them, pick the best answer.
So there won't be a D saying that A and B is correct or anything like that?
No, I think they've done away with those types of questions.
Oh, good.
Yeah. I'm not going to say that they've done away with any all of the above questions, but they're not going to do like just the 2 grouping. So it's either like all or nothing. Yeah. Yeah, those are pretty horrible, especially, Misty, I'll never forget it. I was teaching for a school one time, and they converted this test to a certain testing program, and they had answers like that, were like A and B, or A and B only, or C and D only as choices. But then they like randomized the test answers, which completely screwed that up. And I'm like, well, that just didn't work, did it? Because then it was like basically like changing the order, and it was still asking if B and C were correct. So it was a very funny thing. But, so
They're just hard. They're hard questions.
they are, and a lot of times they're not really formatted well in any context of the word anyway. So how about this one? True or false? A broker of ABC Realty finds out a seller customer is moving to Canada in 2 weeks. A broker is required to reveal this info to his buyer client.
True.
Oh, I'd say no.
I say false.
False.
Folks, read and reread and look at the telltale words.
The buyer client is a telltale, and being a seller
Seller
customer.
Customer.
There she got customer. That's right. Yeah, the seller customer and the buyer client.
Yeah. So a broker finds out confidential information about a customer. So do they have to disclose that to a client?
Yes.
Yes. Yes. Folks, you always have to disclose customer confidential information to your client, but you can never disclose client confidential information to a customer. These words are everything. They're so powerful. Customer, not our person. Client is our person that we're going to bat for. Everybody okay with that statement? Now, I'm going to let you answer this one based on your current knowledge, but I will add a caveat to this one, okay? True or false, an exclusive buyer agency agreement is legally terminated once the buyer closes on the property.
True. I mean, that seems true.
Yeah, there you go. Remember, one of the ways that an agency agreement would end is fulfillment of purpose. If your job is to help them buy a house, you help them buy a house, fulfillment of purpose, that would end it. Now, here's the one kind of supplemental caveat to that. When we look at our buyer agency agreement in North Carolina, the written one, there is an option, if you're working with an investor, let's say, to basically put on there, this will not end when we close on a house. It will only end when a date hits. And that way, if you're helping somebody buy 10 houses, you don't have to redraft it 10 different times. But this was just a very simplistic true or false. Would fulfillment of purpose end an agreement? Yes. And y'all got that. So, of course, we could have more detailed questions that would allow you to understand that, you know, multiple properties could be purchased with one, but we're not there yet. So that's the agency jazz in a nutshell, okay? It is so important that you know client is our person. Principal is the other name for our person. Customer, not our person, never will be. Those are so powerful in a test question. They are the make or break in getting an answer right sometimes. Dual agency is when the firm represents the buyer and the seller in the same transaction. Designated agency, or also designated dual agency. If you see the term just designated on the test, it's the same thing as designated dual. But you cannot think designated dual agency unless something tells you it's designated dual agency. Otherwise, you default to dual, which is the worthless one, the not saying anything, the bound and gagged one, right? Fiduciary is that person in the position of trust. Material facts are anything that could change the outlook of a party in completing a transaction, and real estate brokers have an obligation to discover and disclose these to everybody, not just their clients, customers as well. We owe the material facts to. And then subagent literally translates to agent of the agent, not to be confused with a very specific terminology called seller subagency, which could be in-house seller subagency or cooperating brokerage seller subagency. Isn't this fun? Are we having a good time?
Isn't it break time?
Almost. Listen, if looks could kill, Stephanie would have already murdered me a couple times. When I said, isn't this fun? Stephanie's just like, what if I can stab that man through a computer screen?
I don't like this part.
I love this part.
There'd be 100 math questions in this.
I know you would. I don't know that your peers agree with you.
Oh.
All right, it's break time now. You can have it. So, if you've loved everything we've talked about thus far, well, boy, do I have news for you. You're also going to love everything we're getting into, because it's a lot of the same, just beefing it up a little bit and getting into a few more specifics, because now we're going to be talking about the actual agency contracts, right? You have a good understanding about agency and representation and how it's formed and the disclosure. But of course, there's some information we need to get into on the very specific buyer agency agreements, the listing agreements, the different types, pros, cons, what triggers what, things of that nature, okay? So the whole point of this section is to just have those conversations. Talk about agency contracts, which are necessary for us to be entitled to compensation. Kind of talk about our roles within these relationships, and kind of everything in between. Now, we've already talked about some of this stuff, and so it'll just be like a really brief repeat as we hit those sections. But when we're dealing with compensation in North Carolina, I'm going to reiterate it, folks. It is impossible to be legally paid for real estate brokerage in North Carolina without a written agency agreement. I told you North Carolina does not recognize what we referred to as an implied agreement, suggested by our actions. So we have to ultimately have a written agreement, and every agreement at its inception has to be expressed, which I told you means stated. So even oral buyer agency agreements have to be stated. So these agency contracts entitle us to being compensated. And of course, aside from that, we need to have a current and active license with these agency contracts. And then when we're dealing with listing, the verbiage that we typically use for being entitled to compensation as a listing broker is this last little note right here. Procuring a ready, willing, and able buyer at terms acceptable to a seller. That is typically the trigger on a listing agreement. Now, there's slides in here, but yet again, I find that I like to just explain some different things to you, folks. So let me start off with, before I show you the document, that there are 3 different types of listing agreements that are testable. 3. And I'm going to fast forward here because I think I've got them somewhere right here. There. I'm going to start here. Listing agreement, I told you, or better yet, you tell me, remind me, who are the parties to a listing agreement?
The agent, as in the whole agency, and the seller.
Seller. The agent and the seller. Okay, those are the parties to a listing agreement. Folks, it seems silly that I keep asking you this, but I'm going to be completely honest with you. I can't tell you how often we throw out a test question like, the agreement that outlines the relationship between somebody interested in purchasing property and somebody who is going to represent them as their agent would be identified as what? And people pick listing agreement. Even though it says the document that would outline the relationship between a buyer and an agent, people pick listing agreement. So I'm really beating this into your head so you don't miss these silly questions like that. So a listing agreement is an agreement that outlines the agency relationship between the seller and the agent. And there are 3 types that are testable. These 3 that you see on your screen right now. Open listing, exclusive agency listing, and exclusive right to sell listing. Now I'm going to explain these to you as I have a tendency to do without any slides, without anything mucking it up for you. And then of course I will give you the slides version in a second. But I find that if I explain this before I show you an actual document, you're in a better place. So I want you to think back to the thing I told you earlier. Exclusive means what?
It means that it can't be, you can't have the opposing party be within the same brokerage firm.
So that is what we talked about earlier. Now remember, I said that I was going to introduce the word exclusive again, same meaning, different context. And that's exactly what I'm doing right now. Folks, exclusive means just 2 parties. And this really helps you understand the relationship piece, okay? Now, folks, listen. Y'all said yesterday, I made a couple, far-fetched, jokes, if you will. And I hope I've not offended any of you, but as long as everybody's okay, I'm going to use a very kind of far-fetched comparison with this one as well. And please send me a private message right now if I've offended you in anything that I've said throughout this class, because it's never my intention to offend you. It's just that there's some connotations that can help you remember certain testable concepts. And so if anybody wants to send me a private message right now, I will change the way I teach this. But if you're fine, I promise it's not that bad. You'll get what I mean when I get there. I just want to make sure. Okay. So we all understand. Yeah, that's exactly right, Justin. That's exactly what I was thinking. I'm not teaching, elementary school. I mean, we're all adults here. And so, but I like to be politically correct as an instructor. So I never want to offend anybody. So when we're dealing with, mostly, that's right. When we're dealing with exclusive, right? I picked on Jacob and I used the example. Well, folks, I want you to think of this just like relationships, okay? Well, what is an open relationship?
It means you can have more than one sex partner.
You didn't have to use that word in it, but sure. You're right. You could have just said partner.
It means everything is open. Anyone you can date.
Anything, right? Open, right? Multiple people. That's right. Listen, my goodness. So, yeah, you're right. So that's where you're exactly where I'm going with this. Folks, if you understand these words in a relationship, it helps you understand. But I'm going to take this a step further, okay? So just like an open relationship, you can have multiple partners. We'll just say partners, okay? In an open listing agreement, you can have multiple partners as well. And so it is, all of these, you have to understand, are listing agreements. So in an open listing agreement, here's what happens. A seller will hire multiple brokerages, brokers, firms to try to find them a buyer. And here's what happens in an open listing agreement. Only the person who finds them, or the broker who finds them a buyer, would be entitled to compensation. That is called an open listing agreement. So you would hire multiple brokers, firms, whatever you want to call them, to try to find you a buyer. And only the one who finds you a buyer would be entitled to compensation. Now, here's where I'm going to put that connotation into this that I hope I don't offend anybody with. Just like in an open relationship, you may have needs that you need satisfied, okay? So I want you to understand this. You've got this open listing agreement where the seller says, if you take care of my need, I will compensate you. But understand that just like a relationship, if somebody doesn't take care of your needs, can't you always just take care of it yourself? Some of you nodded way too fast on that. Hell yeah, we can. Mm-hmm.
Yeah, we can.
Without hesitation, Dora's like, absolutely I can. You know? And so that's exactly how an open listing agreement works. Okay, so understand, the seller looks at multiple brokers and they say, if you take care of my problem, the problem being I need a buyer, I will take care of you, pay you. But the seller also reserves the right to find their own buyer, take care of it themselves. And so they're not going to take care of you anymore. In other words, if they find their own buyer, they're not going to pay you. But if you find them a buyer, they will pay you. Does that make sense?
Yeah, but it'd be smarter for them to find their own buyers so they don't have to pay nobody.
Right. But sometimes you don't want to take care of it yourself, so you're hoping somebody will take care of it. Right? But sometimes you got to roll up your sleeves. They're like, I guess I'm taking care of myself. Right? But did you see the connotation there? And this is how you should think about this. So in an open listing agreement, they have hired multiple brokers to try to find them a buyer, and only the broker who brings them a buyer would be compensated a real estate commission. But they could also find their own buyer and pay no brokers nothing, which means all of their efforts could have gone wasted. Does this make sense for everybody?
Yes.
What you got, Adriana?
So if it's, for example, a for sale by owner, but a broker approached the owner and said, I have a buyer for you, would he suggest to be paid if he gives him the buyer?
He could request to be paid, but understand that that wouldn't be a listing agreement per se, right? A listing agreement means I have made a promise to you to attempt to find you a buyer, right? We've made some agreements here. If you were just a for sale by owner and I've never met you before, I'm probably not going to go out of my way to try to find you a buyer and then try to negotiate some money, right? I'm going to negotiate some money and then try to go find a buyer. But yes, in theory, if you had a buyer that you were representing already as a buyer's agent, you would want to be paid potentially by a seller. But don't ever confuse that relationship with any of these listing agreements.
It all need to be in writing too. So
yeah, in North Carolina, all of these need to be in writing. Absolutely.
Because a for sale by owner is an open listing, right?
No, and a for sale by owner is I'm not using a broker. I'm taking care of it myself.
Oh, okay. Because if a buyer has a broker, he won't want to deal with a for sale by owner.
Correct. But if a buyer has a broker, what is that broker to the buyer?
Say it again.
If the buyer has a broker, what is that broker to the buyer?
Broker, it's agent. He's the buyer's agent.
The buyer's agent. So they may work with a seller, customer, but that's not the same thing as a listing agreement. That is cooperating with an unrepresented seller while you represent a buyer. Don't bring listing agreements into that relationship, though, because listing means they have hired us to market their property for them, try to find them a buyer. There's a difference between them marketing themselves as a for sale by owner and us having a buyer that's interested in their for sale by owner. So open listing is actually hiring brokers to try to find you a buyer. You look at, let's just say 10 people. You look at all 10 of them, say, if any of you bring me a buyer, I will pay you 2.5%. But if I find my own buyer, none of you are getting nothing. That is what makes it a listing, because we have actually hired brokers, but there's no exclusivity. It's open. Whoever takes care of my problem, I'll take care of them. But if none of you take care of my problem, I'm taking care of it myself. That's right. The Bachelorette of Real Estate. Pass out flowers or something. Now, here's the thing. Let me explain the context thing here, okay? When I said buyer agency, I said exclusive, right? Think exclusive because we only care about the buyer. I said when we say seller agency, think exclusive because we only care about the seller. When I'm talking about an exclusive buyer agency agreement or an exclusive listing agreement, it's the same word, but a different context. When we said exclusive buyer agency, that was us to them. When we say exclusive listing agreement, that's them to us. Because exclusive buyer agency, we're exclusive to them. We're only looking out for their best interest until what arises?
Yeah.
Say it again.
Wouldn't it be a sale? I mean, once you extend.
No. What would change us being exclusive? What would make us no longer exclusive to them?
Okay.
Dual agency.
Dual agency. So when I say exclusive buyer agency, that's only going until it's not. Because if they allow us to do dual could arise and we're no longer exclusive. But when I say exclusive listing agreement, that means they can't have another listing agent. It's just me. And they can't ever have another one. So do you see the different context? When I say exclusive buyer agency agreement, that's saying they can't have another buyer agent. When I say exclusive listing agreement, they can't have another listing agent, right? But if I say exclusive buyer agency, that means we're exclusive to them. But the second dual arises, we're not exclusive to them anymore. Do you see the different context? Same word, same meaning, different context.
Can you please just restate the exclusive buyer agency? You said us to them, they can't have another.
Yeah, we're going to talk about the buyer agency, but it's true of both. If we say an exclusive buyer agency agreement, that is, they are exclusive with us. They cannot have another buyer agent. It's just our firm. If we say exclusive listing agreement, that's them to us. They can't have another listing firm. So when we're using the term exclusive in these agency contracts, that's them to us, not us to them. Because what you'll find is these actually authorize dual agency, which means, yes, we're going to start off as exclusive to you, but we may become dual agents and no longer be exclusive to you, but you still have to be exclusive to us. Yeah. Kind of a double-edged sword. I can have another partner, okay, but you can't. That's some weird taboo crap on TV, right? I don't know what show that is, but... So now that you understand the word exclusive, okay, exclusive agency listing agreement, they have hired one firm to market their property. And this is going to be a very standard type of marketing. They're going to put in the MLS. They're probably going to offer compensation to a cooperating buyer agent firm. And so basically, if our marketing efforts of marketing their property produce a buyer, the brokers are going to get paid. But yet again, even though it's just us in this relationship together, folks, let me use the same connotation here. Do you think there's ever times where people who are in an exclusive relationship still sometimes take care of themselves?
Yes.
Dora, you are way too fast to answer this every time. Yes. So in an exclusive agency listing, they have hired us to handle the marketing efforts. And if any of our marketing efforts produce a buyer, the brokers are getting paid. Probably the listing agent and the buyer's agent, because we offer to share our compensation with them. But in an exclusive agency listing agreement, the seller can yet again find their own buyer. They can take care of themselves. And if they find their own buyer, they're not paying us anything. We're the only ones they hired, but they have reserved the right to take care of it themselves if we can't do the job. And so if they find a buyer before we find them a buyer, they will sell to that buyer. They don't have to pay us anything. Josh, which part are you confused on?
My brain timed out. Hang on. That's the exclusive agency listing.
Yes. We are currently talking about this one. It is exclusive. There's that word between the seller and one firm. One firm is handling the marketing efforts. And if any of our marketing efforts produce a buyer, we get paid. However, the seller can find their own buyer and pay us nothing. Talk to me, Josh.
I mean, I'm just a little bit confused, so I can't really contextualize it. I really can't explain like where I'm confused at. It was just like in that moment when you were describing when you were differentiating them, I still was just like.
No, don't worry. I'm just explaining verbally right now. You will have slides that kind of associate these to words on a screen too. Okay? This is me explaining so you don't have like words on the screen muddying things up. And then I will reiterate it. So hang tight and you might be okay. So an exclusive agency listing, they've hired one broker to do the marketing. And if any of that marketing efforts from that broker, result in a buyer, they're going to pay the brokers or the broker, and they're going to share their compensation. But they reserve the right to sell it themselves and not pay the broker anything. So the last one on the list, the exclusive right to sell listing. Yet again, you see this word, exclusive. So they are only allowed to work with us as their broker or their agent. But here's what you have to understand about the exclusive right to sell listing agreement. If we find a buyer, we get paid. If another broker brings us a buyer, we get paid. If the seller finds their own buyer, we still get paid. It does not matter where the buyer comes from in an exclusive right to sell listing agreement. We are getting paid no matter what.
So why wouldn't you want it to be an exclusive right to sell listing always? So you make sure you get paid.
We would.
Right. That's the one that
we would.
Probably we would. But I don't think that, I mean, lots of times don't the sellers, really kind of have a big say. Right? They could say, I'll hire you, but only as an open listing or an exclusive agency listing.
No. In the real world, the sellers don't know that these things all exist.
That's what I was thinking. I didn't know it.
Yeah, there you go. So, yeah, we more often than not utilize an exclusive right to sell listing agreement. Now, some high-end markets like New York will use open listing agreements. Like if you ever watched like Ryan Serhant, they'll use those because if the commission is based on a $25 million, New York high rise, yeah, you'll put some efforts in even for an open listing to make a, $700,000 commission. potentially by bringing a buyer. So open listings do exist in certain markets, but in North Carolina, we more often than not always use an exclusive right to sell. So I want you to use the same connotation I've been giving you, though. Okay, understand that no matter who took care of the problem, we take credit for it, right? So we could take care of your problem and we're going to get paid, or somebody else could take care of your problem and we're going to get paid. Or you could have taken care of your own problem and we look you in the face and we say, you're welcome, and we're still going to get paid.
Quick question.
Yeah.
Let's say I'm in this exclusive right to sell, and a buyer's brought, right? Do I need to? And I know this has happened. I remember that. But do I need to pay a referral fee to whoever brought the buyer?
Hang tight. It's not a referral fee at that point, folks. You got to understand how this normally works. What typically happens, and when you look at the agency agreements, it's going to make more sense. I'm going to show you this agreement in just a second. What typically happens is I will say to the seller, or somebody will say to the seller, well, Mr. and Mrs. Seller, we're going to charge you a 6% commission. And of that 6%, we're going to offer 3% to a cooperating buyer's agent. So in other words, if you bring us a buyer, we're giving you 3 of that 6, which leaves us with 3 or whatever. So we offer that compensation in the multiple listing service. Not a referral fee. It's a cooperating brokerage fee to a cooperating buyer's agent. So I'm going to give you the visual on these now, okay? I said open listing, multiple firms, and only the person who is the selling. Remember, selling means brought the buyer. Only the person who brings the buyer would be entitled to any compensation. But the seller retains the right to sell it themselves and pay nobody nothing. That is an open listing agreement. Just like an open relationship, there are multiple people trying to take care of this job. But only the one who takes care of it gets paid. And if the seller takes care of it themselves, they're paying nobody nothing. Okay. It's an open listing agreement. These are all types of listing agreements. Every single one of these is a listing agreement. Relationship between the seller and a firm or multiple firms, depending on which one we're talking about. So then the next one was the exclusive agency. Be very careful, folks. Those two, the last two, both have the word exclusive in it. But one is exclusive agency, one is exclusive right to sell. And so in the exclusive agency, some of you look like you're still writing. I'm sorry. I'll leave it up for another second.
You did say you had uploaded these, right?
They're all in the group me that you have access to this entire deck of slides. And there's still another, 120 slides that we haven't gone over yet. And so you already have access to those too. So the next one, the exclusive agency. Okay, they hire one broker, one firm, whatever you want to refer to it as in this situation. And if any broker is a procuring cause, the reason it says any broker is because we are offering cooperating compensation to a buyer's agent. So that's what I said, through our marketing efforts. So we're advertising it, we're offering to share compensation, and if any of that results in a buyer being produced on our behalf, then we are entitled to be paid. However, the seller retains the right to sell it themselves and pay us nothing. So picture this. You sign an exclusive agency agreement with, a seller client, and you go and you list it, you take photos, you put it out in the MLS, you've had some showings, and none of them have turned into anything. And then one weekend he goes to church and finds out that his pastor is interested in buying his house. They work out a deal. They're going to pick up the phone. The seller's going to pick up the phone and call you and say, hey, I just found my own buyer. I'm selling it to him. Sucks to suck, Chuck. Go to hell. So they're going to say, you're not going to get any money. You're kicked out because they found their own buyer. That is an exclusive agency listing agreement. So the last one, folks, as I told you, is the exclusive right to sell. You've got to make sure you keep these separate in your mind. Okay, exclusive agency versus exclusive right to sell. Does not matter where the buyer comes from, we still get paid. So let me circle back around to that previous example, okay? We list it, we market it. None of our marketing efforts have produced anything. The seller goes to church one Sunday. Their pastor wants to buy it. They connect us together. Says, hey, I found my own buyer. We say, great. Let's get them under contract. You still have to pay me. Doesn't matter where this buyer came from. We still get paid. Exclusive right to sell listing. This is the most common. This is the one I'm going to show you in just a moment.
That's the one that's 13 pages, right?
Yeah. For now.
Don't say that.
It was 11 a couple years ago. So the offer to purchase and contract that we're going to look at in the next section was 12 or 13 pages when I got my license. It's 17 now. So these things get added to. Once upon a time, it was a one-page document.
Back when I sold it was 7.
7. Yep. There you go. It adds more and more and more. That's right. How are we feeling on the differentiation between these listing agreements? Everybody okay with the concept here?
Yeah, it wasn't the definitions that confused me. It was the examples that you were using, and I was just trying to like put them all together, and I guess I just got lost in the middle of them.
Okay.
But no, I get the definitions. I just wish I could refer back to the example.
The example. It's probably better, right, Josh? Because we were talking about taking care of everything, and there may have been something weird in there that kind of...
It wasn't that. It wasn't that. I got you.
I wonder which part you were confused on. You did better now, Kirsten? Yeah, you're good? Yeah. That's why I do it that way. I explain it, and then I give you the visual, so you kind of have something to group it to.
The thing is not the real visual.
Yeah. We're talking about selling houses, Stephanie. Okay? The good people were confused. Oh, well.
I guess I wasn't a good...
I was going to say, that's very, very presumptuous of you. And I was going to say the good people. Y'all were all good people. I don't know. Now, folks, I'm going to back up a little bit here because I wanted to explain the different types. Okay, I'm going to go back to, kind of the beginning of this section. And so when we're dealing with these, you need a listing agreement. And of course, when this is talking about procuring a ready, willing, and able buyer on terms acceptable to the seller, that's actually the verbiage used in that exclusive right to sell listing agreement. Of course, there'd be a little more insight into what would actually be triggered because a buyer in and of itself is not enough to get you paid in the other two. Depends on where that buyer came from. But a buyer in and of itself is strong enough to get you paid on an exclusive right to sell listing agreement so long as it's on terms acceptable to the seller. So I'm going to show you the actual form, and I'm going to point out only what I think are the most testable pieces because, as Stephanie mentioned, there are a lot of pages to it, and I don't want you to freak out and get overwhelmed by all the things. So I'm really going to point out what I consider to be the most testable items within it.
Lost my highlighter.
Pull this up here. So the one that I'm pulling up is very specifically the exclusive right to sell listing agreement. And the answers on the test, when you're having those questions on the three different types, are going to be very specific to the type. Now, I will give you a word of caution while I'm kind of just talking to you while I pull this up. Be very cautious of test questions where they will throw things into the mix like such and such has an agency agreement by way of an exclusive right to sell listing agreement. And then the question has nothing to do with the specifics of that agreement. It's something else completely different. So they will sometimes throw in these words as additional information that you don't need. So sometimes the question will be based on, well, what does that mean for this scenario? Other times it's just extra fluff. There we go. So I had some fun hunting these documents all down. This should be it. Okay. Here is the exclusive right to sell listing agreement. And there are a lot of pages, but I'm just going to point out some individual pieces that I, once again, deem the most testable. You have access to these within your textbook program, down where we have all these sample forms, so you're welcome to navigate through this a little bit more. So let's start with the top, okay? Exclusive right to sell listing agreement, stating that that's the type of agency agreement that we're entering into. But then this first paragraph is kind of important. This should sound like what we've been talking about. This exclusive right to sell listing agreement is entered into between blank as seller of the property described below and blank as listing firm, because the firm is the agent. Now, understanding subagency, right? The individual agent who signs this agreement shall, on behalf of the firm, be primarily responsible for ensuring that the firm's duties hereunder are fulfilled. However, it is understood and agreed that other agents of the firm may be assigned to fulfill such duties if deemed appropriate by the firm. For the purpose of this agreement, the term firm, as the context may require, shall be deemed to include the individual agent who signs this agreement and any other agents of the firm. Everybody at the firm. That's how that subagency piece works, right? If Misty signs this, yes, Misty's going to be the one working with this seller. But if we all are affiliated with the same firm, technically we all, as it starts out, work for the seller. Now this blue box isn't super important. This is just making sure the appropriate party has signed this. If we're dealing with a deceased person's estate, they better be the executor or the person in charge of it. If it's an entity, they better have the signatory authority. So this is just outlining times where, we want to make sure that the right person is signing this. In consideration for firm services and efforts to find a buyer for the property, firm is hereby granted the exclusive right to sell the property on the terms and conditions set forth in this agreement. There it is again, exclusive right to sell.
Seth, can I ask you a quick question?
Sure.
At the top where you put the seller's name, would you put like Stephanie Staten, or would it have to be like Stephanie Renee Staten? Is it their legal name or just the name? Because like in titles for cars, you have to have your legal name, but other stuff you can just sign.
If you were ever tested on it, the best thing is full legal name. It would also be appropriate to say first name, middle initial, last name. But then the other big thing for testable purposes, if they go that route, you need to clarify, like, if we had John Doe and Jane Doe, it's not enough to put John Doe and Jane Doe. You would need to put and spouse, because we need to know their relationship, because they could be siblings, they could be spouses, and that matters because of title. So the legally appropriate name to name spouses, like John Doe and Jane Doe, let's say both of their middle initials are also J. John J. Doe and wife Jane J. Doe would be the best, most legally appropriate way to fill this out. Does not have to be all three names, but first name, last name, middle initial at minimum.
I was just saying the line's not very long for some people's names.
Well, yeah. The text gets smaller as you fill it in.
So,
yeah.
Okay.
So here's a little kind of like disclaimer thing, right? Because I told you that working with real estate agents disclosure is kind of step one. So if they're seeing this, folks, they better have already seen the working with real estate agents disclosure. So that's what it says. Seller represents that as of the effective date, the seller is not or will not be, if the property is currently listed, a party to a listing agreement with any other real estate firm regarding the property. Seller also represents that seller has received a copy of the working of the real estate agent's disclosure and has reviewed it with the firm. So number one, we're making sure you're not working with anybody else. Why is that important? Because we're entering into an exclusive agency agreement. And then number two is you have in fact reviewed the working of the real estate agent's disclosure with the seller. So I told you in North Carolina there are 4 things, and this is a section, so I'm going to go ahead and tell you all 4. 4 things required to be in every written agency agreement in North Carolina. Definite termination date, signatures of the parties, the individual broker's license number, and something called the prescribed non-discrimination provision, which deals with fair housing. These 4 things, and you're going to see them again later, but the reason why I went ahead and mentioned them is because we start talking about the timing on this. So the term of this agreement shall begin on its effective date and shall end at 11:59 p.m. on its expiration date. The effective date is this agreement shall become effective, and the seller and firm's respective rights and obligations under this agreement shall commence as follows. You got 2 options the way this is drafted. The date that everybody signs this agreement could be the effective date, or there is this possibility that they are in a relationship with another broker, and when that relationship ends, they want to hire us. And that's what this second piece says. The property is currently listed for sale exclusively with another real estate firm. Seller represents that the current listing agreement expires on this date, and so the effective date of this agreement that we're filling out shall commence immediately upon the expiration of the current listing agreement. Now, I told you on day 1 about the differentiation between realtors, brokers, and agents. And so not all brokers are realtors, but all realtors are brokers. When you are a realtor, you are bound by a code of ethics. And that's what this is referencing here. Part of the code of ethics says you can't steal business from other realtors. So according to Article 16 of the Realtors Code of Ethics, realtors shall not engage in any practice or take any action inconsistent with exclusive representation or exclusive brokerage relationship agreements that other realtors have with clients. And I'll talk more about this later whenever we get into some solicitation laws very shortly. So here is the end date, because we have to have a definite end date. So this agreement shall terminate at 11:59 p.m. on whatever date. So that self-destruct feature. If we've not done our job and this date and time hits, it's dead. You turn to customer, you're not a client anymore. Can we renew it? Sure. Could we sign a new one? Sure. Could we extend it? Sure. But without doing any of that, it will die.
So, for example, that's like if I asked you to sell my house and we decide that it's 6 months down from today. So that would be the date that would go there.
Yep.
Okay.
That's exactly right. So here's where things start to become a little more full circle, okay? Well, the property that is the subject of this agreement shall include all the real estate described below with all the appurtenances thereto, including the improvements located thereon, and the fixtures and personal property listed in paragraphs 3 and 4 below. You've heard all these words before at this point. But here's where we put in the street address. Who remembers what we call the street address? What did we refer to that as?
I don't remember what we referred to it as, but it has to be like the legal, and not the actual address, but the way that you get to it using like one of the 3 different methods.
Description.
There you go. We need the legal description. Folks, the street address is called an informal reference. It is not enough from a legal point of view. Sure, it's enough for inviting your friend over to a barbecue, but it's not enough. So yes, we start out with that, but look what happens here. Reference to the lot and block method. Reference to a recorded plat, right? Reference to a deed. Now, there's no like meets and bounds description within this, but we are referencing the lot and block method, reference to a recorded deed using a tax ID number, because we need to be sure that we know exactly which property is being conveyed here, exactly which one we're talking about. Now, folks, this section right here, this goes back to early on in class when we talked about fixtures and personal property. And so I told you, There are certain things that we include to be appurtenances, fixtures that go with the real property would stay for the new buyer. And there are things that are personal property that get to leave with the seller. But not everything is outlined. We have this generic thing for pre-licensing, nailed, screwed, glued, or buried. It's probably a fixture. But in the real world, it's more complex than that. How do we handle it? A list. And you don't ever leave any ambiguity on the contract. So this listing agreement is the opportunity for us as real estate agents to have a discussion with the seller on what is considered a fixture and what is not. So we would sit here with the seller and we would say, well, let me first point out this morning. The party should not assume that an item will or will not be included in the sale based on an oral or written statement or understanding that is not a part of the sales contract. Buyer and seller should be specific when negotiating what items will be included in or excluded from the sale. And so this is an opportunity for us to look at the seller and say, hey, listen, per this list, if it's in your home right now, it's a fixture, it's supposed to stay. Do you have a problem with any of this stuff staying? So it is the time for us to have the conversation with the seller. That's very important in the brokerage world. This is one of our big jobs. And so then conversely, we would say, okay, well, is there any personal property that you're allowed to take that you want to leave here? And so this is our opportunity to have that discussion with them. And then what we would need to do is make sure that this gets into the sales contract. Notice how it points out. This stuff that we're about to talk about in this listing agreement, it's mirrored on the sales contract. So this is the time that we talk about it with the seller, but then it needs to be relayed again between seller and buyer on the sales contract. So there's a pretty detailed list here. Alarms, security systems, doorbells, antennas, basketball goals and play equipment permanently attached on the ground, ceilings, wall-attached fans, light fixtures, exercise equipment permanently attached, wood or coal stoves, garage door openers, landscape trees excluding potted plants, swimming pools, hot tubs, mirrors attached to wall ceilings, cabinets, landscaping, storage, all this fun jazz. Now, we'll talk a little bit more about this again when we get into the contract section because this looks identical to what it looks like on the sales contract. It's just, this is us having a conversation with the seller about it on the listing agreement. And then on the sales contract, it's the conversation between the buyer and the seller on what stays and what goes. And I told you, the only time we need to mention personal property on the sales contract is what?
If the seller, you talking about personal property?
Personal property.
If the seller doesn't want to take it with them.
Yeah, or more specifically, the buyer wants the seller to leave it, right?
Yeah.
The only time we talk about these things on the contract is if we want them to do the opposite of what they're supposed to do. So let's say that you have all the ceiling and wall attached fans. Well, folks, we're not going to make special mention of them on the contract. They're already on here. So the only reason we'd make special mention of them on the contract is if we wanted to take them with us. And so if you want to exclude something, it goes right here. Other items that do not convey. The following items shall not convey, and you identify it. If there's personal property that's supposed to go with the seller, and we want to leave it for the buyer, put that here. The following personal property present on the property on the date of this offer shall be transferred to buyer at no value at closing. So if you want the refrigerator, ask for it here. If you want the washer and dryer, ask for it here. Anything that would be personal property slated to go, ask for it here. Now, this home warranty section, not super pertinent, and I'm kind of breezing over some stuff because, you know, we've, of course, got a whole lot to still talk about, number one tonight and number two in general, because this is just a non-stop class. You know, I honestly, folks, we could probably have this set up as a 140-hour class, and I still would be talking the entire time, if that puts it in perspective for you. So I'm sorry, I'm just assaulting your ears every single night, but we don't really have a lot of time to, you know, lollygag with all the information. Say what, Stephanie?
I said, we still have a lot to go over.
Uh-huh. That's exactly right. It don't stop.
Do your thing.
reading, Seth. Don't apologize.
I appreciate it. Sometimes I just feel bad because I'm like sitting here and I'm just going and like I can just see the anguish on some of y'all's faces, and I'm starting to feel like I'd be really good at torture. You know, like no, you can hire me. I got this. All right, I'm good at torturing folks. I do it for a living. Yeah. So let's get into the really important pieces of this, okay? All this stuff is good and it's important and you could be tested on it, but I'm really focusing on the most testable pieces of this listing agreement. And I'll do the same thing with the buyer agency agreement. Home warranty is not going to be on your test, okay? That's just a negotiating tool. Let's talk about this one right here. List price. Seller lists the property at a price of blank on the following terms. And so this is where the seller has a conversation about what would be deemed acceptable. Are we okay with a cash offer, an FHA loan, a VA loan, a USDA loan, a conventional loan? Are we going to allow them to do loan assumption? Now we're going to talk about these different things in detail in the financing section. But let's say that they were okay with just these. It's okay for a seller to decide that. I'm okay with cash, I'm okay with FHA, I'm okay with conventional. And what they're going to also have to put in here is what would be a price that they would like. So maybe it's $400,000. And so then it has this very interesting line right here. Seller agrees to sell the property for the listing price or for any other price or on any other terms acceptable to the seller. Now I'm going to make a very important statement that completely contradicts that line, but you have to understand this. Folks, if you were to get an offer for $400,000 and it was cash, FHA, or conventional, and there's no contingencies, we have deemed that this is an acceptable offer. But contrary to what this says, the seller does not actually have to sell the property. There is no point in time where you can force a seller to sell. But I'm going to make a very important statement. Even if they elect not to sell once that offer comes in, they still have to pay you. Because you have done your job. I'm going to read this to you in just a second. Hang with me. Now I'm going to ask another question before I go down and I explain what I just said a little more in detail. Right here, it says, or for any other price or on any other terms acceptable to the seller. Well, how would you know if anything other than this was acceptable?
You would just have to ask.
It's crazy how simple that is. If the seller stated that, yeah, I'd be okay with $395, that makes it acceptable. So if they go to accept an offer less than this, you've still done your job. You've never automatically done your job when you get an offer less than this. But if you get an offer in for, let's say, $375 and the seller says, yeah, I'll accept it, you've done your job. From a your due compensation point of view, don't think your job stops there. It doesn't. Okay? So let me explain what I'm saying here. You would outline what the seller wants to sell for, and then you would come in here and you would talk about what you expect to make as the listing broker, the listing firm. So the seller agrees to pay the firm a total fee of 6%, 7%, whatever it may be, of the gross sales price of the property, or you could put a flat fee, which shall include the amount of any compensation paid by firm as set forth in paragraph 8 below to any other real estate firm, including individual agents and sole proprietors, talking about cooperating real estate firms. Now, here's what I just mentioned. There are three little subsections under fee earned. When you have earned your commission. So, the fee shall be deemed earned under any of the following circumstances. 1, if a ready, willing, and able buyer is procured by the firm, a cooperating real estate firm, the seller, or anyone else during the term of this agreement at a price and on terms set forth herein. Well, folks, there's that exclusive right to sell piece coming through. It clearly states it doesn't matter where this buyer comes from. So if a buyer is produced, no matter where they came from, at terms acceptable to the seller, we call that a ready, willing, and able buyer. We've technically earned our commission. Now, folks, let's talk about ready, willing, and able. What does that mean?
They're ready to initiate the transaction and willing to move forward, and they're able to forego possession of the property.
Well,
So they should already have found their financing.
there you
So
go.
funding is secure, there's no contingency, hopefully they're clear of everything.
There you go. They want to buy the property. They have put an offer in on the property, and they can buy the property. Ready, willing, and able. Somebody coming and saying, I think I might like to buy that. You haven't done your job. Well, heck, if I had it, I'd pay $500,000. You haven't done your job. Ready, willing, and able buyer. They have to want to buy it, put in an offer to buy it, and be able to buy it. At that point, technically, you have earned your commission. Now, folks, please understand, before I go any further, a lot of students get so caught up on this. No, this does not mean that anytime we get an offer, we shut down and we stop doing anything, and we just look at the seller and we say, pay me, and I'm leaving. The only time you really get paid under that criteria is if the seller changes their mind. If you get that offer of $400,000 at the terms that they said they would accept, no, they do not have to legally sell it. So when that offer comes in and they say, no, I've changed my mind, I'm not going to sell it. Okay, they don't have to sell it. Pay me my commission and I'll walk away. Because they hired you to do a job, you did the job, them changing your mind has nothing to do with doing your job. It'd be like taking your car to a mechanic, then fixing it and being like, I changed my mind. Too bad. We've already fixed it. We're not unfixing it. Pay us. Does that make sense? The only time that one comes into play is if they try to get out of it, back out, or change their mind. Otherwise, our job is to really get it to closing. We're going to talk about that in a second. What were we saying, Kirsten? I'm sorry.
So, good night, sweetie. If you bring a buyer, they put an offer in, but it's less than the listed price here, you know where I'm going, right? And the seller does not accept the offer, you still will not get paid.
Correct. You haven't done your job. It would have to be either perfectly at what you've agreed to on provision 6, or the seller would have to state, I will accept this, and then actually not accept it. There has to be something that identifies that it was at terms acceptable to the seller. And unless they state it, it will never be acceptable to them unless it is at list price with no contingencies or better.
So your job is to negotiate to get both parties to an agreement to be paid.
Well, your job is to get the most money for your seller, and ultimately then you get paid by proxy, right?
Okay, I guess I'm thinking if I'm representing the buyer.
Well, and we're not worried about the buyer yet because we're only talking about the listing agreement.
Okay,
Yep.
I was confusing myself then.
Yeah, we'll talk about the buyer and their circumstance and all of this when we get to the buyer agency agreement. Right now, we're just saying, well, we're charging the seller some money. We're going to do a job for a seller. And yeah, we're going to share that money most likely with the buyer's agent. But the buyer's agent has their own conversation when they sign that agency agreement. So we'll get there. What you got, Sam?
So just out of curiosity, let's say that the seller lists the property at a price of $400,000, and you find a buyer that is super eager to buy the house, and they put in an offer like $420,000. That'd probably be unrealistic, but just for...
It's not unrealistic. It happens all the time.
Okay. And then the seller backs out and says, I changed my mind. I don't want to buy the house. But you guys had the agreement at 6% commission. Do they have to pay you the 6% commission on the $400,000 that they put in the contract, or the $420,000 that was offered?
The $420,000 that you were under contract on or potentially got. But yet again, that's a really good question for real world. It's not going to come down to the test. But because that was the offered gross sales price, that's the only thing we can base it off of. Because, of course, list price is what we're marketing it as, but that's not necessarily what we're going to end up accepting. So it's always based off of the sales price. Yeah, good question. The second one is the more realistic one, folks. This one, ready, willing, and able buyer, terms acceptable to seller. You will get test questions on that. You do have to know that your fee has been deemed earned, but in the real world, that's not typically how we're getting paid, because we're not just like walking away and absolving ourselves. So typically the second one's the trigger. If the property is sold, option, exchange, conveyed, or transferred, or the seller agrees during the term of this agreement or any renewal hereof to sell, option, exchange, convey, or transfer the property. Us selling the property, helping them sell the property, that's what typically entitles us to a commission. The only time I told you that one really gets triggered is if they try to back out and we've already done our job. Now the last one, number 3, I'm going to tell you something interesting about it before I let you go on break, and then I'll explain it a little bit more in detail. Okay, number one, not number one. First thing in regard to this third one right here. Before I even teach you about it, it's basically worthless. But more realistically, it is extremely testable, and it has 3 names. Of course it does. You know, why would anything in real estate only have one name? Doesn't make any sense, right? So it is called, and you need to know all 3 of these names because you could see them on the national portion of the test, because we all have very similar things in our agreements, nationally speaking. It is called a tail clause, like a dog tail, T-A-I-L, an extender clause, and a protection period. It's got 3 different names. Tail clause, extender clause, and a protection period. I'll explain why those names come into play and what it is when you get back from break, but go take a break. So we are currently looking at one of the 3 testable types of listing agreements, and it is the exclusive right to sell listing agreement. And we're looking at these specific provisions in this one, talking about when your fee is deemed earned. And so, of course, we said number 1 was if you procure a ready, willing, and able buyer at terms acceptable to the seller. 2 was if they sell the house or agree to sell the house. And then this third one I told you has 3 names, and it is known nationally. And so it could be called an extender clause, a tail clause, or a protection period. Now, the reason why it's called an extender clause, a tail clause, or a protection period is because it extends to protect you past the tail end of your agreement. Meaning after it ends, it's basically a provision that survives beyond the expiration date. So here's what it says. If the circumstances set out in 1 or 2 above have not occurred, and if within blank amount of days after the expiration date, we're deeming the protection period, seller either directly or indirectly sells, option, exchanges, conveys, or transfers, or agrees to do any of those things with the property upon any terms whatsoever to any person with whom the seller, firm, or any cooperating real estate firm communicated regarding the property during the term of this agreement or any renewal hereof. So basically the idea here is to protect ourselves if the seller tries to sell it to somebody that came about during the term of this agreement. In other words, holding out, waiting for the agreement to end, and then trying to sneakily turn around and sell it to them. The problem why this is, the reason why, and the problem with this, and the reason I told you it's worthless, is because of what it says next. Now, they're not really going to test you on the worthlessness of it. They're going to test you on when does it trigger, what's it called, things like that. But the reason why this is worthless, it says, provided the names of such persons are delivered or postmarked to the seller within 15 days after the expiration date. So in other words, you've got to provide a list to the seller. Here's all the people that I'm talking about. If you try to sell it to any of these people within this period of time after the date that our contract ends, you would potentially owe me a commission. The other thing that it goes in to say is, however, seller shall not be obligated to pay the fee if a valid listing agreement is entered into between seller and another real estate broker, and the property is subsequently sold, option, exchange, conveyed, or transferred during the protection period. And what that's basically saying is if you hire somebody else, that changes things, right? Then they can be obligated to pay this new person, and sucks to suck for you. So I promise you from a national point of view that extender clause, tail clause, protection period, testable. I've seen it. I know it. Testable. I've seen it when I took the Colorado exam, not the North Carolina exam. I haven't seen the North Carolina exam, but, you know, National is national. So these are all the triggers of when you've earned your fee. Okay, fee earned. Well, let's talk about when you actually get paid, because those are two very different things. Yeah, you may have earned your fee under one of these. Here's where it says when you're actually paid. Okay, once earned as set forth above, the fee will be due and payable at the earlier of distribution of proceeds from sale of the property by the closing attorney. So that's the main time you're going to get paid. Closing. Even if you think you've done your job before closing, folks, you got to get it to closing. Otherwise, you're not getting paid. That's the time we typically get paid. 2, the seller's failure to sell the property, including but not limited to seller's refusal to sign an offer to purchase for the property at the price and terms stated herein, or on other terms acceptable to the seller. The seller's default on an executed sales contract for the property, or the seller's agreement with a buyer to unreasonably modify or cancel an executed sales contract for the property. In other words, this is where I told you, if you've done your job by procuring a ready, willing, and able buyer, your job is to get it to closing. But if the seller refuses to sign that agreement, refuses to sell it, backs out of a contract, unreasonably modifies the contract, all of those things could constitute a seller's failure to cooperate and could trigger the need for them to pay you now, because they're no longer getting it to where it needs to go. And of course, the last one just says, or the seller's breach of this agreement. If you have earned your fee and they just outright breach, pay us now. Now, I mentioned earlier that there were some different laws and rules, and we talked about, I think it was last night, in regard to like kickbacks, and I basically gave you a couple pieces of insight. And I said, well, as long as you disclose any bonus, rebate, commission, or otherwise, or kickback to your client in writing, you're entitled to collect that compensation, and as long as it doesn't violate RESPA. Well, this is where it says that. It basically states, if additional compensation is offered, you agree that we're entitled to it, but the firm shall timely disclose the promise or expectation of receiving such additional compensation and confirm the disclosure in writing before the seller makes or accepts an offer to sell. So here's another important piece. Earlier, I showed you where we tell the seller how much we're charging them. Mr. and Mrs. Seller, we're charging you 6%, some of which may be offered to a cooperating firm as outlined in paragraph 8. Well, here's paragraph 8. Cooperation with / compensation to other firms. Firm has advised the seller of firm's company policy regarding cooperation and the amounts of any compensation that will be offered to other brokers, including but not limited to seller subagents, buyer agents or both, brokers who do or do not participate in a listing service, and brokers who are or are not realtors. Seller authorizes firm to, and then here's where you check all that apply. So you could check this box that says cooperate with subagents representing the seller and offer them the following compensation, 2.4, 2.5, whatever, 3%, whatever we're offering to them. Or this box, cooperate with buyer agents representing the buyer and offer them the following compensation, same thing, 2.4, 2.5, 3%. I'm changing the number because it's very locale specific, what we kind of offer as a shared compensation depending on your area. So don't get so caught up on one number here. You may or may not see the number that I'm articulating, which is why I'm throwing out multiple. And the last one says cooperate and compensate based on an attached firm policy agreement. Now, folks, let me see if you can piece this together, okay? If we were to check this box, but not this one, what does that mean? You check the box that you're going to cooperate with and compensate buyer's agents, but you did not check the box that says cooperate with sub-agents representing the seller. What does that mean?
I don't think you're not on a dual agent relationship.
It's not the dual agent relationship that comes into play here. Now understand that this entire provision deals with cooperation, because we said what we're charging as a firm, 6% or whatever. And if there's no cooperating broker, in theory, our firm would keep all 6%. And so that could be a dual agency transaction. So it's not about dual agency here. This is solely with cooperating brokers. I like the honesty. Jacob says I'm going to be real with you. I got no idea. Nothing.
I'm just going to say, I don't think it means anything, because if you have agent that is representing the seller because a buyer won't go into an agreement, still a sub-agent.
Let me expand it for you, okay? Let me give you a scenario. Misty, you call me up as an unrepresented buyer, and you call me and you said, Seth, I found you online. I want to see 123 Main Street. Say, great, Misty, I'll meet you there. What's the first thing I'm going to go over with you, Misty, when we meet?
Who you represent?
The disclosure.
Specifically, the working with real estate agents disclosure. I don't represent anybody yet, but I've got to tell you how it works, because remember I told you in North Carolina, if you're about to show somebody a house, first substantial contact is happening. So I'm going to say, Misty, here's the working with real estate agents disclosure. I could be your buyer's agent. There's also this thing called dual agency. Of dual, there's this thing called designated. And understand, Misty, you could be an unrepresented buyer. You don't have to have an agent. Do you understand how agency works, Misty? And Misty says, yes. I said, great. Now that I've explained it to you and reviewed it with you, I'm going to ask her to sign it. Now, of course, she could refuse to sign, but let's say Misty signs that working with real estate agents disclosure. Do Misty and I have a relationship?
Yes.
No.
All right. No. That does not create relationship. So.
No. Never. Oh, folks, this is why I get so enthusiastic about it. I've seen the confusion that kills students on the test. So the agency disclosure never creates a relationship, okay? So it's just me telling Misty what could arise. Everybody agree?
All right.
Okay, so what's next?
Then you can get a verbal, oral, whatever you want to call it, agreement.
A verbal, oral, whatever you want to call it, agreement. I'm with you, Jacob. Here's what's next. I'm going to ask Misty if I can be her buyer's agent. And yes, we could start off with a written buyer agency agreement, or we could start off with an oral buyer agency agreement, whatever she's more comfortable with. And remember, oral buyer agency agreements. Huh?
I'm a rebel. I say no. You're still a sub-agent of the seller.
You're jumping the gun, Misty.
Okay.
Hold on.
I'm a rebel.
I know, and that's why I picked you for this. You're just not there yet. So
But if she says no, then it's just like, okay, don't use an agent. Do it by yourself.
hold on.
That's what no.
Hold on. You got to let me finish the point here. Y'all missing the point. The point is, I asked Misty if I can be her buyer's agent. And I explained that it could be an oral agreement to start with or a written agreement. And here's what Misty says. Oral agreement, written agreement. You know what? I'm a rebel. And I watch HGTV and Selling Sunset. I don't think I need an agent. I think I got this. I just want to see the pretty house. Seth, show me the house. Folks, can I show her the house?
No.
Why not?
Yes.
I think you can, but you would be representing the seller.
Why would they do work if they're not going to get paid? Because he's not the seller's agent. If he's trying to be the buyer's agent, he's not the seller's agent. Why would he do something he's not getting paid for?
Because
seller could opt to check the box to cooperate with subagents representing the seller and offer compensation.
Okay, so now that we've gone down this rabbit hole, let me ask the question again. What does it mean if they don't check this box?
I don't think it means anything.
You wouldn't get paid because you are a subagent.
It means I can't be a seller subagent. So, Misty, when you tell me you're a rebel and I can't represent you, there's only two people I can represent, the buyer or the seller. You won't hire me. The seller won't let me work as a cooperating seller subagent. So what am I about to do?
Give them the middle finger and leave.
Work for free.
Not going to work for free. I'm going to say, Misty, don't let the door hit you where the dog should have bit you. I'm out.
Yes.
So how would they know, Seth, that the seller didn't agree to it with this listing agreement? How would they know that?
Because we have this magical thing called the multiple listing service where we advertise our willingness to cooperate with and compensate one, the other, or both. So I'm going to look in the MLS, Misty, when you say I can't be your buyer's agent, I'm going to look in there and it's going to say I can't be a seller subagent, and I'm going to say deuces. I'm going to go to the nearest bar, take 3 shots of tequila, and forget you wasted my time, Miss Rebel.
I know, right? So what if you're not a realtor? What if you're not a realtor and you're just a real estate agent and you don't have access to the MLS?
Well, doesn't.
Hold on, pause. Isn't that an incorrect statement? You can't just be a real estate agent.
No, you can.
You're either a broker or a realtor.
And so let me provide the first piece of clarity, just so we're all on the same page. Because here's the first piece of clarity. Now, Misty, where are you from, Misty?
California.
California. Okay, well then that's not even the South. Just so we're all on the same page, folks. I'm going to say this again one more time. It is pronounced realtor. Now, you can pronounce it any way you want after you understand that it is, in fact, pronounced realtor. And the reason is because you don't go see a doctor when you're sick, so don't put that extra syllable in there. It ain't necessary, okay? But now that I've made my peace with it, it is realtor. But you can be a real estate agent without being a realtor. The problem is non-realtors don't get access to the multiple listing service. But the thing would still stand. Notice what it says right here. Brokers who do or do not participate in a listing service, and brokers who are or are not realtors. But that doesn't change anything with this. This is just saying we will or will not work with people working with working as a seller subagent. Broker, realtor doesn't matter. We are or are not authorizing you to work as a seller subagent. So if we're not offering that, you can't do it. Your only option is to be the buyer's agent, or you're not in it.
I'm schooled, Seth.
Okay, so that part makes sense, but hold on. The whole realtor broker thing, my understanding. Okay, a real estate agent is somebody who is a member of the realtor.
A real estate agent is somebody who represents the well-being of a party in a real estate transaction. Remember, an attorney is an agent, okay? An agent is somebody who represents other people. When I say agency, it has nothing to do with real estate.
I thought that whenever you threw the word realtor anywhere, the correct way would be is if they were a member of the Realtor Association.
That is the correct statement. But don't bring agent into that.
Okay, so that's what I'm saying is you're a broker or a real estate agent. All real estate agents are brokers.
No. You're using realtor and real estate agent as synonyms. They are not.
Okay, that was my confusion.
Yes. You are a realtor because you joined the Association of Realtors. You are a broker because you have a real estate broker's license, which is what this class is going to get you. And you are a real estate agent because in your authority to broker a deal, you represent people. But there are 10 billion types of agents. Tom Cruise's agent is not a realtor. That is a celebrity's agent. There are lots of agents.
Yeah, no, I understand that. I just thought that you were considered.
No, real estate agent is just because you're doing real estate and you're representing somebody. It has nothing to do with a realtor.
Okay, thank you.
Yep.
That was my confusion. I thought
Yep.
that you just weren't considered a real estate agent unless you were registered.
No. Yep. Even a broker is a real estate agent when they represent somebody. Realtor, those are all three technically different terminologies, but you can be all three simultaneously.
Yeah, and I get that.
Yep.
I just had that.
Yep, that's good. All good. So y'all have answered my question now. This is what you would check if you were going to authorize cooperating seller subagency. I told you it's not common because of that vicarious liability thing. If an agent from XYZ authorizes an agent from ABC to also represent their seller, they're opening themselves up to liability by not knowing if they are a good or a bad agent. So we just have to have that discussion with the seller. Are we going to work with and cooperate with and compensate seller subagents, buyer's agents, or both? That's it. Yeah. So the last couple things that I'll point out, we've already kind of learned in a roundabout way. Please be very cautious. I told you in this class, we have very few, next to none, absolutes. So be very cautious of words like an agent guaranteeing anything. You will see a lot of questions that say, well, what is a listing agent doing for the seller? And one of the options will be like, well, guaranteeing we're going to find him a buyer. No. Be very cautious. Guarantees exist for those deeds. Guarantees exist for loans, but they don't exist for what we do as real estate agents. So I'm not going to say that they don't exist, but be very cautious. So here's what this is saying, that a couple things that we're outlining for us as a firm. We are putting forth our best efforts to find a ready, willing, and able buyer. We're going to do our darndest. That's what we're promising. We are going to give it a good old college try. This also clarifies, and this is a very important North Carolina specific rule. It says seller acknowledges that real estate brokers are prohibited by North Carolina Real Estate Commission rule from disclosing the price or other material terms contained in a party's offer to purchase, sell, lease, rent, option, or otherwise. So let me explain this. When we get into the offers section, I'll talk about this a little bit more, but it's called shopping offers. If I was, let me draw you a quick picture here. If I was the listing agent and I get an offer from a buyer's agent and that offer is for $405, and then I get an offer from a different buyer's agent and that offer is for $410, I am not allowed to go back to this person and say, well, hey, I got an offer for $410, will you beat it? That is prohibited in North Carolina. You are not allowed to disclose the terms of the offer without permission of the person whose offer it is. And I want you to think about that. Imagine being the listing agent, calling this buyer's agent who's got the winning offer and saying something to the effect of, well, hey, listen, you're currently winning, but I'd like you to ask your buyer to have permission to screw them over and to screw over these other buyers so my seller can make more money. Is anybody in their right mind going to give you permission to do that? No. So that's what this is saying. We cannot disclose terms of an offer, even at the instruction of the seller, because it is prohibited. So that'd be an unlawful instruction once again. The only person who could give us permission is the person whose offer it is. And we're going to talk more about that in the offer section.
I have a quick question.
Yeah, please, go ahead.
Okay. And it might not matter as far as testing. It's just something that I've seen, and I know you said that it's not always right. But like when I bought my property, I know that we had two offers that were the same amount that was offered. So one was like a cash offer and one was a veteran or a VA loan. So as the person that is selling it, how do they basically choose which one they want to take?
You're talking about when you sold your home, you had all these offers that were the same, or when you were buying your house?
No, when I was buying.
You shouldn't know that information. That means they violated the license law and commission rule in North Carolina. If you knew that there was multiple offers at the same price with different terms, then they violated license law. How do they choose which one to take? Whichever one's best for them. If all things were equal, cash is better, right? If there was a conventional loan versus a cash, because cash doesn't require appraisals, cash can close quicker. There's a lot of perks to cash. And so please understand, though, that's if all things are equal, I could tell you which one was stronger just from, normal happenstance. But sometimes the biggest price isn't the best offer because it may have contingencies. It may have a different loan type. It may have an appraisal. It may require repairs. It may, there's a lot of other things. Price is not always the best offer. Best price is not always the best offer. But that's where we would advise our sellers on what we think might be the best for their circumstances, depending on their needs, wants, and desires. And remember, they make the ultimate decision because we are special agents. We just advise them. They make the decisions. There you go. So the next one on here talks about material facts. Just like the RPODES says it, so does this. That, hey, listen, notwithstanding anything else, doesn't matter what you do, we have to disclose anything we know or reasonably should have known. Okay, that's that material facts thing where we say we got to sing like a bird. Whether you like it or not, we've got to. Now, sellers don't have to tell us what's wrong with their property, but, here is another piece of that. Those 4 things that I told you were required by rule in North Carolina under 58A.0104 when it outlines the 4 required things in all written agency agreements in North Carolina. The prescribed non-discrimination provision. So the automatic expiration date or definite expiration date. The non-discrimination provision says the agent, meaning the firm, shall conduct all brokerage activities in regard to this agreement without respect to race, color, religion, sex, national origin, handicap, or familial status of any party or prospective party. Further, realtors have an ethical duty to conduct such activities without respect to the sexual orientation or gender identity of any party or prospective party. That is a non-discrimination provision. Marketing, we of course have to get approval for marketing from the seller. If we want to put signs in the yard, if we want to do coming soon, if we want to put it in the MLS, internet advertising, print media advertising, we get consent from them. We will talk later about advertising rules. There are some that are also pertinent for North Carolina more specifically. I'll talk about those more later. I'm trying to see if there's anything else. No, I don't think that's going to be pertinent to you. No, not that one right now either. Not that one. Nope. Nope. I tell you what I do want to do just really quick because I just realized that my slides didn't catch it. I mentioned one, and this just triggered it. Folks, when we were talking about material facts very recently, we deemed certain things as not material facts in North Carolina. What were they?
You said not?
Not material.
Talking about like somebody being murdered in the
There you go. Somebody being murdered in the house is not a material fact in North Carolina. What else? Someone died.
Sexual predators.
Sex offenders in the area. That's right. Site of criminal activity, haunted. All of these things are deemed not material in North Carolina, okay? But they fall into like stigmatized, may not be desirable. We said you could advise people on them as long as it didn't have anything to do with AIDS or HIV, because that'd be a violation of fair housing. Well, one thing that I did not get into at the exact same time, which I'm going to take an opportunity to get into, we did talk about meth houses. So I'm going to say this again. Meth houses are a material fact in North Carolina. And they are what's called a material fact for life. They never go away. It would be a material fact that that house was a meth lab 30 years ago. There's no statute. There's no timing. It's a material fact for life that it was a meth house. Well, there's 2 other material facts for life, special categories in North Carolina that I absolutely believe you could see on your North Carolina portion of your exam. One of them is right here, which made me think of it. It's called synthetic stucco. It's also referred to as EIFS, which stands for Exterior Insulating Finishing System. Stucco is kind of the stuff you see in like southern areas like Florida and beach communities. It kind of looks cementy. They very commonly will put like seashells and stuff in it to make it look pretty, or stone. And so stucco in and of itself is not a problem. Is somebody unmuted about to ask me a question? Stucco is not bad. Stucco is presumably a good type of siding, but synthetic stucco, instead of being just this solid concrete-y stuff, the stucco, the real stucco, what they would do is they would put like this underlayment, and then they would put this insulating board, and then they would put a thin layer of stuff that looked like stucco. But it was notorious for cracking and allowing water penetration to happen, and it would get trapped behind that insulating board, and it would cause wood rot and mold. So because of that, it was deemed a material fact. And so when I say material fact for life, if a house has synthetic stucco and they remove all the exterior and then re-side it with something else like vinyl siding, it's still a material fact that it was once clad with synthetic stucco. Never goes away. Okay, material fact for life. It's called synthetic stucco, also called EIFS. The last special category of material fact in North Carolina, and I'm going to type this up here so you can see it, is and if I didn't spell it right, don't come after me, polybutylene pipes. But polybutylene pipes if and only if they have leaked. If they've never leaked, it's not a material fact. Jacob, did you say that's right or wrong?
Oh, no, you said whatever the hell that word is, and I said bless you.
Oh, bless you. I thought you like Googled it and like told me if I spelled it right or wrong. I was like, oh, good, thanks for helping me out. No, bless you. Yeah, polybutylene. So polybutylene pipes in and of themselves are not a material fact in North Carolina. I'll give you the quick history. Polybutylene was a very common type of piping utilized. It's not too dissimilar from PEX. It's gray. It's kind of pliable, a little more than PVC, and it says poly-B on it. The reason it got a bad reputation is because it was commonly utilized with copper fittings. The chemicals and stuff in most treated waters would cause some of the metal to leach out of these copper attachment fittings. And so then it would start to leak at these fittings. And yet again, as you might imagine, once it starts leaking, you don't know the exact extent of the damage in the walls, in the crawl space, and the attics, anywhere this plumbing was running. So even if you've ripped them all out and replaced them, it's a material fact for life that they once leaked. The presumption is if they've never leaked, they're probably not going to, because they probably didn't use copper fittings for those. So 3 special categories of material facts for life in North Carolina. What you got, Misty?
How would you find out about the plumbing, that polybutylene? How would you know that?
Go in your crawl space.
Home inspection.
Yeah, I mean, the obvious answer is home inspection. But if you're talking about your own personal residence, if you wanted to know if you had them or not, go in your crawl space and look at your plumbing. And like I said, it's gray and it says poly-B.
Well, I mean, I'm not personally, I'm talking about if you have to disclose it. How would you know that? Like, I understand with the home inspection, but
So same thing with like the synthetic stucco. Understand, we are responsible for what we call reasonably ascertainable material facts. So Misty, if something was a meth house 40 years ago and there's no obvious or apparent records of it, are we in trouble for not discovering it? Probably not. Same thing with polybutylene. If they were ripped out and replaced 20 years ago and there's no record showing us where that happened, are we in trouble for not disclosing it? Probably not. But if we know, it's a material fact for life. If we can find out, it's a material fact for life. Don't get so caught up on the how would you know that. Yeah. This piece right here asks about the liens on the property. That is, of course, important because we need to know what they can reasonably sell their house for compared to what they owe. And so we talked about liens a little bit. We're going to talk more about it in the financing section. But there's a lien attached to the property. It's called a specific lien, which gives the person you owe money to the right to go after that property if you fail to pay this promised debt that you promised to repay them back. So we need to know how much that debt is, because imagine meeting with a seller and them saying they owe $400,000 on the property and you don't think you could sell for more than $350,000. That would raise what's called raise us into a situation called a short sale. And the real quick definition of a short sale is a sale that would be short on funds to satisfy all liens. You couldn't sell it and make enough money to pay off all the liens. That's why it's called a short sale. We'll get more into that later.
How does that even happen? Like, I understand that happens in cars all the time. It's super common to have negative equity in a car. But how does that even usually happen in a home? Because homes are very, very quickly appreciating.
Divestment.
Be careful. Homes have appreciated at a record rate over the past 3 years, more than they have over the past decade. We have had a greater level of appreciation in the past 3 years than most homes have seen in the past decade. Folks, I want you to sit on that for a second. And of course, there's a lot of things that went into it, record low interest rates, probably everybody's grandparents dying from COVID and leaving them cash money. A lot of different things went into this that caused this appreciation. But think about what that meant over the past 3 years. In general, they appreciated, but some people were paying $200,000 or $300,000 more than list price to buy that house. And so part of that's what caused this inflation, this appreciation. But then you have to understand that there were markets where that happened, and then people decided that wasn't the greatest market to be in, and then those markets went stagnant. And now when they turn around and they went to sell, they couldn't sell it for $200,000 less than what they bought it for. So it does very much happen. And sometimes it's due to the economy. There was a community not far from North Carolina, I want to say in like the edge of Virginia, where there's a Miller bottling plant. Every single person in the community worked at the Miller bottling plant. It closed down less than a decade ago, and everybody went upside down on their houses because that was the only place everybody worked. Nobody wanted to live there anymore because there weren't jobs anymore. So it can happen overnight, sometimes through no fault of the seller. It does happen. Even in today's market, there are plenty of areas where you are upside down and have negative equity on your property. Yeah.
I've never really heard of that being like a common thing.
Yeah. It's not common, but it does still absolutely happen. But it's also not something that people go around advertising, right?
There was a lot of that in 2008 when that crash came.
Yeah.
There's a lot of that going on.
To remember, I was in kindergarten. I don't remember 2008.
Right. We're going to talk a little bit about that whenever we get into the financing section, which caused a lot of some financial reform and financial legislation. The Dodd-Frank Act was a byproduct of that. The CFPB, the Consumer Financial Protection Bureau, was a byproduct of that. One of the big things that went into that market was what we call subprime lending. They would give a loan. They probably would have given a loan to Jacob at 6 years old at the time if he had just applied for one, which is one of the reasons why things went so awry in 2008, 2009. So we'll talk a little bit about that. Yeah.
Now you have to make over 6 figures to get approved for a loan.
Yeah, you got to make over 6 figures, and that's to buy the new entry-level home at $380,000, right? You're not getting anything less than that.
As somebody who's been actively trying to figure out how to buy their first home for the last 2 years, it's ridiculously frustrating.
I can only imagine. Because, I mean, folks, just to put in perspective, I think I bought my first home when I was 20. How old am I now? 20, it's been about 26. I was 25, 26, 27, somewhere in that ballpark. No, I wasn't. How old was I? Because I've been in this house 5 years. Either way, maybe it was like 25 when I bought my first house. And I mean, we all see that's a decade ago because I just turned 35. So it was either somewhere between 7 and 10 years ago. And I bought my first house for like $159,000. That doesn't exist in that same area now. It just doesn't exist. That same house probably is $425,000 right now. Now I don't live in that house anymore. I live in a different one, but
That's
If
the
I
same as
find
mine.
a house for $130,000 that wasn't a crack house, I would be a property owner right now.
yeah.
Yeah, good luck with that.
Good luck with that. I mean, it was a beautiful ranch. Three bed, 2 bathroom on almost an acre, 2-car garage. I mean, it was an awesome first house. And I sold it like 3 years after living there for like $200,000. So I made 40 grand off of it in 3 years.
$250,000 now can get you either a very, very mediocre house in the boonies or one of the worst houses you've ever seen in town.
Yeah, absolutely right. Yeah. And there's about 17,000 other people who are willing to put the offer on that crack house with you. And so you can't even afford it, right? Because that price point is such a, yeah, let's not, it's just going to get depressing. Let's not talk about it right now. It's not going down in most of our markets, but it's leveled off, which is what we needed. Leveling off is good. It needed to happen. We've got a little bit of time left. I don't think there's anything else crazy. I am going to reiterate once again, though, the dual agency piece, because I think the Working with Real Estate Agents disclosure did a good job of it. But you need to understand exactly how dual agency works, okay? You have to have informed and written consent for dual agency. Once upon a time, we actually had a dual agency addendum or a dual agency agreement. That doesn't exist in North Carolina anymore. Now there is a dual agency provision within the listing agreement and a dual agency provision within the buyer agency agreement. So if you look right here, and this is going to sound a lot like what I've been teaching you in regard to dual agency as well, because I told you it was worthless. It's dangerous. Why would you do it? But then designated was the best thing since sliced bread. So this is probably where we'll get through tonight. So let me show you this, okay? Here's what it says. Think about this. This is something that we're telling the seller when we're talking about dual agency. Seller understands that the potential for dual agency will arise if a buyer who has an agency relationship with the firm becomes interested in viewing the property. Firm may represent more than one party in the same transaction only with the knowledge and informed consent of all parties for whom the firm acts. Now here's where we talk about disclosure, or basically the lack thereof. Disclosure of information. In the event the firm serves as dual agent, the seller agrees that without permission from the party about whom the information pertains, firm shall not disclose to the other party the following information. 1, that the party may agree to price terms or any conditions of the sale other than those offered. 2, the motivation of a party for engaging in the transaction, unless disclosure is otherwise required by statute or rule. And 3, any information about a party which that party has identified as confidential, unless disclosure is otherwise required by statute or rule. So this goes back to what Monica was saying earlier, right? We can't tell you nothing. Even though we have this obligation of disclosure, we all understand that because we owe it to both of you, we owe confidentiality to both of you, we can't do it. Well, then it goes on. Let's talk about the firm's role as a dual agent. If we are acting as a dual agent, don't throw designated into this. If the firm serves as agent for both seller and buyer in a transaction involving the property, firm shall make every reasonable effort to represent seller and buyer in a balanced and fair manner. Firm shall also make every reasonable effort to encourage and effect communication and negotiation between seller and buyer. Seller understands and acknowledges that, 1, prior to the time dual agency occurs, firm will act as seller's exclusive agent. Well, folks, before I go any further, tell me what that means. That number 1 right there, what does that mean?
Is that dual agency? Adriana, your turn.
Oh, I was just going to say this, the firm, blank. If there's both seller and buyer, they will choose to represent the seller.
It means that you are only acting in the seller's interest. No other party. You're not working with any other party. You are their exclusive agent. Only work.
You only work for the seller.
Let me expand on it just a little bit. Because you're right, but you've got to piece it all together. Folks, remember what I told you. I want you to think about this right now. in just a second, you're going to see lines where the seller will authorize dual. Actually, let me show you this. Right here, this is where they would authorize dual agency, okay? So it says dual agency. They would initial this box. It says seller authorizes the firm to act as dual agent, representing both the seller and the buyer, subject to the terms and conditions set forth in paragraph 17. So here's my question to you. If the seller initials this when they sign the agreement, are you a dual agent?
Yes.
If the seller, only if the opportunity presents itself.
Yeah.
So let's answer this definitively. When the seller signs this that authorizes dual agency, are you a dual agent?
Oh no.
No, not unless the
No,
buyer
this is
agrees.
agent. I'm
They're
not
just
a dual.
authorizing.
The answer is no. That's what that line meant. Even though you have authorized dual agency, we are going to give you exclusive representation up until the time that dual arises, and understand it may never arise. Folks, if I am selling Kirsten's house, I am giving Kirsten exclusive representation until what time? What trigger?
Someone within your firm, a buyer within your firm, with an agent within your firm. I'm saying this wrong, but I know what I mean. It's too late for this. Okay. When a agent with a buyer from your firm comes and expresses interest in purchasing the property that you are representing.
There you go. So let me just re-articulate that. If Kirsten hires me to be her agent to sell her property, and I ask Kirsten if dual is okay, and Kirsten says, yes, I'm okay with dual, I am still giving Kirsten exclusive representation, meaning me to her, up until the time dual agency arises, which means that I would be giving her exclusive representation indefinitely if we only ever had buyers from other firms. But the second that a buyer that is represented by our firm is interested in her property, now I'm a dual agent. That's what that line means. Every relationship starts as exclusive. Even if they've authorized dual, we are not a dual agent until it arises. It only arises when the firm is representing the buyer and the seller in the same transaction. So let me just, and then I'll answer your question, Adriana. So ABC Realty and Seth, right, me, representing Kirsten. We've got buyers coming from XYZ Realty. We've got buyers coming from Keller Williams. We got buyers coming from Coldwell Banker. We've got buyers coming from Century 21. During those times, if anybody puts an offer, if we're negotiating, if they're showing the house, this is all exclusive representation. ABC is exclusively representing Kirsten, and XYZ is exclusively representing their buyer, and so on and so forth. But the second that ABC has a buyer who is interested, it's not exclusive anymore. So it's exclusive until it's not. What you got, Adriana?
Well, I was just wondering if this listing, a buyer see the house and see the sign, and then she calls the realtor, the broker, straight. So she is a unrepresented buyer. Would that be the case that the agent will become a dual agent, or it's exclusively for the seller unless it's a buyer from the firm?
Adult diapers.
Oh.
It depends.
Yes.
It depends. Because if I'm representing Kirsten in this scenario and an unrepresented buyer calls me, I could show them the home as an unrepresented buyer and maintain my exclusive relationship with Kirsten. Or if Kirsten said it was okay, I could make them sign a buyer agency agreement that authorized dual agency and immediately show them it acting as a dual agent. It would depend on what Kirsten wanted. Both are completely allowable with informed and written consent. This is where you've got to read into questions very carefully, because one additional piece of information could change that buyer customer seeing it with you representing the seller exclusively to that person being a buyer client and you showing it as a dual agent, as long as you enter into an agreement and everybody agrees to it. That make sense? So let's finish up this thought here, okay? Prior to the time dual agency occurs, the firm will act as seller's exclusive agent. In its separate representation of seller and buyer, firm may obtain information which, if disclosed, could harm the bargaining position of the party. Providing such information, so we still might know confidential information. Firm is required by law to disclose to seller and buyer any known or reasonably ascertainable material facts. Be very careful on test questions. They're going to give you questions like, well, you know, Kingsley is acting as a dual agent. Which of the following would be okay for Kingsley to disclose to a buyer? That the seller's roof leaks, because that's a material fact that you owe to everybody, regardless of representation. So don't let agency throw off material facts disclosure questions. Now, here's where it gets really interesting to wrap up the night. Seller agrees firm shall not be liable to seller for 1, disclosing material facts required by law to be disclosed, 2, refusing or failing to disclose other information the law does not require to be disclosed, which could harm or compromise one party's bargaining position, but could benefit the other. And here's my favorite part. Now we're talking about the seller, right? Mr. and Mrs. Seller, here's your role if I'm acting as a dual agent. You ready for this? This is great stuff. Watch this. Should firm become a dual agent, seller understands and acknowledges that seller has the responsibility of making the seller's own decisions as to what terms are to be included in any purchase and sale agreement with a buyer client of the firm. In other words, I can't give you advice. Figure out what you want to offer. 2, seller is fully aware of and understands the implications and consequences of firm's dual agency role as expressed herein to provide balance and fair representation of seller and buyer and to encourage and effect communication between them rather than as an advocate or exclusive agent or representative. So again, not advocating, bound and gagged and worthless. 3, seller has determined that the benefits of dual agency outweigh any disadvantages or adverse consequences. And here's my favorite. You ready for this? 4, seller may seek independent legal counsel to assist the seller with the negotiation and preparation of a purchase and sale agreement or with any matter relating to the transaction, which is the subject matter of a purchase and sale agreement. In other words, you can hire an attorney to do my job for me, but you still have to pay me. Does this sound like what I taught you? It's worthless. I can't give advice. I can't help anybody. And we even go so far as to say, are you sure? Are you sure you're sure? And you can't come after us if you don't like the outcome unless we break the laws or the rules. Now, just one last point here. Designated dual agency is referenced. When a firm represents both the seller and buyer in the same transaction, the firm may, in its discretion, offer designated dual agency. If offered, designated dual agency prevents the firm with prior express approval of both the buyer and seller to designate one or more agents to represent only the interests of the seller and a different agent or agents to represent only the interests of the buyer. So understand when they're filling this out, they're going to say yes or no, right? Yes, dual agency. And then this is authorizing them to yes or no. Am I okay with what I call true dual? Remember when I used Eliza yesterday and I said Eliza was representing the buyer and the seller? We now have it outlined that we need specific permission. Is that okay? Legally, it's okay, but we need to ask the seller, is it okay for the same individual agent to represent you and the buyer? Or do you just want it to be the firm? Either way, they're bound and gagged and worthless. And then it goes further on to say, of dual, do you want designated? So this basically says if you pick this, we will default to designated unless prohibited by law or you say otherwise. And then the big doozy one is, well, if they don't want dual at all, they would initial exclusive representation. And you already told me what happens if they do that. that has now limited the pool of buyers that can see this listing. Because if they want exclusive representation only, that means every single buyer represented by our firm cannot see this listing. How are we feeling?
Can I ask a question?
Sure.
So on the exclusive representation, if the buyer calls you and ask about a property, and you will say if he has a broker that he's working with and he does not, so then you will have to tell him you have to get a broker because I cannot represent you, or how?
Okay, so let me make sure I understand the question. If we're representing a seller and the seller says they want exclusive representation only, and the buyer calls you and they say they want an agent, obviously you can't represent them. So if they want an agent, you would have to help send them to another agent. Yes? Is that your question?
Yes, but then can it be an agent from the same firm?
No, because that'd be dual agency.
Okay, so then what would you do in a situation like that?
Okay, if I am the listing agent and I work for ABC Realty, and an unrepresented buyer calls me, okay, Sam's the unrepresented buyer, she calls me up and she says, Seth, I'd like to see that house and I need an agent, can you represent me? I'm going to say nope, because the seller wants exclusive representation only, but I'm going to refer Sam to you, Adriana, that works for Coldwell Banker, and I'm going to ask you for a referral fee. I'm going to say, Adriana, there's a buyer that I can't work with because I'm giving exclusive representation, so our firm can't work with her. But if I send her to you, will you pay me a referral fee? And of course, you're going to do it, and I'm going to make more money, and there's no conflict of interest because you are exclusively representing Sam. I'm exclusively representing the seller.
So that is legal.
It's very legal.
But you cannot tell anything that you already know to Sam.
Absolutely not. She is an unrepresented buyer, so I would never tell her anything in the first place. And then I'll just send her over to you, and I'll say, good luck. You help her out.
Oh, yes, I meant to the realtor, yes.
Yeah, I wouldn't tell anything to you either. Yep.
But you still would benefit.
Yeah, because I'd make a little bit more money than I was going to make.
Okay.
There you go.
Thank you.
Jacob, I would expect as much, folks. That's why I kept calling agency the doozy chapters, right? Ain't no joke.
I was fine yesterday, but I have a lot of head pressure right now. I've had a headache this whole time, and it's a lot of information.
It is more than. I always joke, it's like drinking from 3 fire hoses at once.
Yeah.
Well, Jacob, I don't have a headache and I understand completely.
Meaning, she understands completely your trials and tribulations. She understands the material completely.
I don't understand. I'm going to have to study this section like 500 million times.
Yep.
Yeah. I mean, yeah. Can I go to bed now?
And the book doesn't address it in any really good detail.
No, it doesn't.
Now, of course, the extent to what I'm getting into a lot of the different listing agreements are outlined, but this is a weird section in the textbook, and I'll pinpoint it and I'll share them with you. This is a weird section because it talks about it in one section under the agency agreements, and then of course there's another section for North Carolina, and I'm kind of trying to go back and forth between them because these agreements exist in every state. And there's similarities in every state, but then some of these things are very specific to the way we look at them in North Carolina. And then again, some states don't even do dual agency, but we absolutely do, which is why I have to go into such detail on it. So it's a lot, but I promise as time goes on, I will tie back to this subject multiple times, and we're not done talking about it. I still got a little bit more in this section to go through with the buyer agency agreements and commissions, do some commission math, and some other agency disclosure laws that we'll get into next week.